Okay, we're going to go ahead and get started with Programs Committee. And I will, well, I won't gavel in the meeting, but this is the start of the Board of Trustees meeting for today. And the chair is not here, it's not available. So as the vice chair, it's left to me to sort of run the show a little bit here. So first, I will call for the chair's report, which since chair's not here, I'm not giving a vice chair report. But I'm going to call for public comment. If there's anybody, do we have anybody on the phone? I don't think so. No phone calls? Okay, we'll start with the roll call.
Okay.
Okay, hold on. We'll do roll call first, okay? And then we'll do your public comment.
Okay. Mark Broughton. Here. Hyland Chen. Sonia Delon. Here. Ruben Duran.
Present.
Jason Lee.
Here.
Joanna Mendoza.
Here.
Josh Pertula.
Here.
Sean Selig.
Here.
Alan Steinbrecher.
Here.
Brandon Stallings. And Debbie Manning.
Here. Okay, there's been a gentleman in the audience who indicated he wanted to speak. Public comment. Can you coming up to the microphone, please? State your name.
My name is Jose Castañeda.
Go ahead and have a seat. You can have a seat. Please sit down.
I'm okay fine standing, if that's okay.
If the microphone picks you up, we need to make sure you record it.
I filed a federal complaint against the State Bar, the Superior Court, and obviously the Commission on Judicial Performance. This is regarding two inheritances that were stolen from me. The Pasadena Superior Court has been closed due to the corruption. I have documented multiple incidents or crimes, if you might want to call them, where when you represent yourself, you're at their mercy. You are basically at their mercy. There is an attorney that has been disbarred, Mr. Jack Conway, an attorney that has surrendered her license, moved to Oregon, surrendered her license down there. She's back here in California. And I refiled a complaint where the complaint was basically manipulated because in
Okay, hold on. Because you're so far away from the mic turned off.
Michael Flanagan and also Mr. Anderson as well. So the complaint was manipulated in that sense that her name was removed from. So my question is, how can a $2.3 million estate just disappear? Just, nothing was given to my mother. She was 75 years at the time. It is related to the murder of my brother in county jail. I spoke with Sheriff Leroy Baca. He never got back to me. So we have people that have been killed in jail and nothing is done about it. It's all about making profit for the attorneys. The question that I have is, how can the State Bar see all the complaints that I made in a timely fashion with plenty of evidence, including Mr. Conway, who has been disbarred, and I lost all my cases because of this individual. I want to know if there's anything that can be done by the new State Bar, as it is claimed. And I also share this information with Ms. Vanessa Holton. And I want to know if it's the old ways of doing things, or is there really a new State Bar here that we can hold people accountable? Because when they come to court and lie, just lie about even a contract or being retained, I think that's where we need to focus in stopping the lies by the attorneys.
Okay.
Thank you.
Thank you. Is there any more public comment? Okay, we're going to go ahead and get started with our agenda. And we're starting with, we don't have anything on consent, so Section 3A, adoption of revised goal for race, diversity, and inclusion. Donna and Helen.
Thank you, Madam Chair. Members,
I have displayed for you there something you are very familiar with, and that's the State Bar mission statement. I think each and every one of you and the staff of the State Bar are proud of the fact that in May 2017, the board adopted the current mission statement, which includes the responsibility to support efforts for greater access to and inclusion in the legal system. However, until this past January, the strategic plan failed to include any objectives regarding the bar's mission to support efforts for diversity and inclusion. We remedied that, you remedied that at your January planning session when you added 9 concrete objectives related to diversity and inclusion. At that time, you also adopted a definition of the categories that we're referring to when we're addressing diversity. So what do we mean? And we mean race, ethnicity, disability, gender, gender identity, sexual orientation, and veteran status. However, time constraints prohibited the board from adopting revisions to Goal 4. As you can see from what I have projected, Goal 4 is currently limited to access and doesn't deal with diversity and inclusion. Now that the board has added those 9 concrete objectives related to diversity and inclusion to the plan, we thought it was important to go forward and amend Goal 4 to address diversity and inclusion issues. So following the input of from the Diversity Summit that the State Bar conducted in August of this year, which several of you were present at, following discussions with the Council on Access and Fairness and the extensive board discussions at the planning session that you held in January, staff is proposing the following goal. That we support access to legal services for low and moderate income Californians and promote policies and programs to eliminate bias in the legal profession, promote an inclusive environment for attorneys and the public they serve, and ensure that the statewide attorney population matches the demographics of the state's population. 2 things I wanted to point out about that goal. First is that in discussions with the Council on Access and Fairness, they would ask that the goal reflect that we ensure that the statewide attorney population and the judicial population match the rich demographics of the state's population. Because of discussions that we all had at the planning session, and we'll be talking about a little bit later today when we talk about COAF's work plan, the staff are not proposing adding that we match that the judicial population matches the demographics of the state because of the sort of discussion about this State Bar really transitioning leadership of judicial diversity issues to the Judicial Council. The one other thing I would mention about this goal is, although if you look on your agenda item, page 2 of the item lays out the goal in exactly these words, in the resolution, inadvertently, it doesn't capture these words. So this is what is on page 2 of your agenda item, and what is on this slide is the goal that staff is recommending that the board adopt.
Did you want to say anything, Donna, about, or just to point out that we recognize the last part of this is aspirational and long-term. And as we discussed at the planning session, there are interim steps and measures that we could employ to determine whether or not we're making progress.
Yes, absolutely. And I think that's what goals are supposed to be. They're supposed to be aspirational. The objectives should be ambitious but achievable, but the goals should absolutely be aspirational. And having the attorney population match the demographics of the state is not something that we anticipate accomplishing by the end of 2019 or 2020. But I think all of the objectives that you all adopted about the pipeline and retention and career advancement, looking at the data and figuring out where to focus our interventions will ultimately lead us to that point or move us in the right direction toward that point.
Does anyone have any questions of Donna? Alan?
Yes, Alan Steinbrecher. I very much am in favor of the goal in general, but I have a couple of words that worry me a little bit because I think they set too high a standard or give us problems in the future. The first is the word ensure, which means we promise to make it happen. I might suggest that we substitute for ensure strive to achieve, or some words like that. The second word is matches, and again, that could be construed to, come to a very close percentage or other measure of the diversity of our state. So I would propose a word like reflects or something to that effect. I do understand that these are aspirational goals, but as written, I do worry that they might be set as objectives that are just simply may not be achievable, or achievable in a certain time period, or just constrain us too much.
Do you want to propose that as an amendment?
Sure, I will propose that as an amendment. Did you get that?
I can read that back. So it would be support access to legal services for low and moderate income Californians and promote policies and programs to eliminate bias in the legal profession, promote an inclusive environment for attorneys and the public they serve, and strive to achieve a statewide attorney population that reflects the rich demographics of the state's population.
Yes. Well,
Instead of matches, I would insert reflects.
She did. That's what she said. She said that. Did just say catch up. Didn't type fast enough.
That reflects, Justin.
so
Okay.
I don't think there's a motion on the table, so I will construe Alan's comment as a motion and to adopt the item as amended, and I will second.
Second.
He's a second. Is there any more questions? Is there any more questions or debate on this? Jason?
Hey, thanks, Donna. In the discussions that you had with COAF and their request to add judicial diversity to the mix, I guess I'm not so concerned about that, but rather matching what's in the statute, and I think the language is legal system, to this, which is narrower. Maybe if there was a discussion about that, if you could add a little flavor to that.
So the statute does talk about access to and inclusion in the legal system, and that access and inclusion are part of our regulatory part of the exercise of our admissions, licensing, and regulatory functions. There, as we will talk about, I think in more detail later, the Council on Access and Fairness has historically played a significant role in efforts to improve judicial diversity. Excuse me. They are very concerned that if they don't continue to play that role, and if the bar does not continue to make that a focus of the work of the bar, that there will be a void and others won't step in to have that goal of improving judicial diversity. That's contrary to the discussions that the bar leadership staff have had with the Judicial Council, who has expressed their interest in taking a leadership role in this. They do have and have had for a number of years as one of the Judicial Council, the court system has as one of their strategic plan goals, increasing the diversity of the bench. Council on Access and Fairness has pointed out correctly that despite the fact that has been one of their strategic plan goals from at least since 2006, there hadn't been a lot of activity by the Judicial Council to implement that goal, and so that's why they're concerned about wanting to make sure that the bar keeps it front and center, so that somebody is doing that. Again, our conversations with the Judicial Council suggest that the Judicial Council it recognizes its past role has been somewhat passive, and they are interested in taking a leadership role and moving forward.
So
And I think maybe to help, because I think I understood your question a little bit differently.
yeah, it was a little different.
So I think the distinction is, does that concept of diversity of the legal system need to be reflected in our goal statement, or does that mean that our work in this area can in fact include elements beyond diversification of the attorney population. And I think the objectives that we have identified and the board already adopted do in fact support the notion that we would be working more broadly on diversity of the legal system, specifically vis-a-vis the judicial population, because we do have an objective in our strat plan now about supporting the Judicial Council in finalizing the toolkit, rolling it out, and implementing it. So the distinction that I see is, where are we going to hold ourselves accountable as an organization, not simply where are we going to, in what space are we going to work. So we will do some work on judicial diversity, as you'll see, but it's not going to be front and center for us as an organization. And our goal statement reflects how we believe we should be held accountable. And I think that is for the work that is primary and central to our organization. So I think they fit together, but one is at the forefront and one is less emphasized.
Okay, yeah, and I remember those discussions relating to judicial diversity, and I did not mean to rehash that. It's just more of the difference between what's in the statute and what we're adopting. That just gives me a little pause. I don't believe we should include judicial diversity in our mission statement, but are we too narrow in light of what the statute says? I mean, I guess in my view, we keep with sort of the theme of the statute, but then we have already clearly articulated what we're going to do, which is geared towards most of what's reflected there, and then the toolkit. So I guess that's my thinking. I just want to ensure that we're matching or paralleling the statutory language, so that we're seen to sort of embrace what the legislature has sort of messaged to us.
How would you rework it? Support.
I was hoping that Alan could do that.
Promote an inclusive legal system. I mean, one of the things we were trying to do here is articulate a measurable goal, even if it is ambitious. And so when you broaden it to the legal system, it becomes more amorphous and more difficult to hold us accountable with respect to.
Can I weigh in on that?
Yeah, Joanna?
I see it as being implied from the statement, because when you're working hard to achieve diversity of our law students and the attorneys in our legal system, there's this implied outcome that it's going to create a more diverse and inclusive legal system in whole. We have to start at the bottom and work our way up, but it all comes from making the profession itself diverse and inclusive, and it follows from that. So I see it more as implied from what we're trying to achieve, without having to directly state it in a way that too much might be read into it.
Can I ask a dumb question? Exactly which statute are we talking about? Can staff give me a citation?
I believe it's in the staff report, right? Business Professions Code 6001.1. Is that what you're talking about, Jason?
Yes.
Yeah.
Vanessa?
You can preface it at the beginning and then say that includes, and then follow with the rest of the language there.
So I think that even Alan's amendment wasn't necessary with achieve a statewide attorney population, because then we say, well, what about judges? I think you can say eliminate bias in the legal profession, promote an inclusive, eliminate bias and promote an inclusive legal profession. That covers attorneys and judges and the public they serve. That reflects. So once we just mention attorneys, then the question comes up, what about judges? But as Leah suggests, legal profession includes both.
Right, and I guess even your comment, Joanna, makes me think about law students and all the pipeline work
Exactly.
as well. So I think that seems.
So you want me to read it? It would go, support access to legal services for low and moderate income Californians, and, that'd be A and D, promote policies and programs to eliminate bias and promote an inclusive environment in the legal profession and the public it serves. In the legal profession, yeah, take out attorneys and the public it serves. And let's see if that works. And the public it serves. It's probably grammatically better.
But you have to change the they to it.
And then I would even take out, sorry, Ellen, I would take out the part up, from and through population. Let's just try it. And that reflects the rich demographics of the state's population. And that covers attorneys, judges, and everything that you, I think, intended.
I don't necessarily agree with that, Madam Chair. I think it's important that we talk about increasing the diversity of the attorney population, specifically as part of this goal.
This is not our state bar mission statement. This is our goal within our strategic plan. So I'm concerned about this. It's too broad. Yeah, I think we should be more specific about what we're trying to do.
Do you disagree with the change that Vanessa made? It's up there now?
I guess I don't want to say I disagree with it. I think it was better before. So I don't disagree. I think we should take a stand and make a commitment to work to diversify the attorney population. That's what we need to do. We've said we were doing that and focused on that for the last 20 years, but I think it's time to be held accountable for it. So personally, I think the goal should be specific in that regard. I don't think it's in conflict with the statute, personally.
I guess the way I thought about the goal as I placed some importance on it matching what's in the statute, and then the specific objectives can be whatever fits within the goal, which is why I like it matching the statute. And then the board can always, as it has, identify the specific goals that fit within, the specific objectives that fit within the goal. And it gives us, one, a lot of continuity with this and the statute, but we have identified very specific objectives to achieve. So I guess I do like this, and it does identify, Leah, to your point, it does say at the end about the attorney population.
If we want to match the statute, I think instead of legal profession, it should say legal system. The statute says system, not profession.
No, there's a motion.
Oh, there's a motion. I apologize.
We have a motion on the floor. Well, we didn't vote on it yet. I mean, you can withdraw it.
We should have voted on it because now it's not up.
Well, no, I mean, once we have the motion, for him to speak on it, you just speak on the motion. So he spoke on the motion. It's actually Alan's motion. Sean's the second. It's Alan's motion.
Now that you've woken me up, what do you want me to do?
do you want to accept a friendly amendment to the language that's up there, or do you want to go back to the one that you originally were proposing?
Sean?
Let me make a Alan, let me offer a suggestion, which is, Leah, I know you're looking to have, the very last clause of this is something you want that's specific and measurable. So I wonder if, just looking at the draft, I mean, we have goal 4 in the original draft, and then we have these specific sub-objectives. Would it make sense to make the last clause of this about statewide attorney population an objective? So you sort of have the overarching principle at the start, and then you have these specific measurable objectives underneath that. Would that be more consistent with your vision of this?
Oh, I think right.
No? Okay.
Yeah.
Never mind.
No, to me, the objectives, I kind of see what she's saying, though. The objectives are what you're saying. The goal is stating, we want to have more diverse attorney population, then these are the objectives we're going to use to get to that. We're waiting for Alan. It's Alan's motion, so he can accept the.
And what would the friendly amendment be?
What's on the screen?
Oh, it's on the screen?
Yeah.
Yeah, I'm fine with the friendly amendment.
Sean, are you still fine with the second?
Yes.
Okay.
I'll accept it.
Okay. Any other comments? Okay, we can call the roll.
Broughton? Dillon?
Yes.
Duran?
Yes.
Lee?
Yes.
Mendoza?
Yes.
Pertula?
Yes.
Salig?
Yes.
Steinbrecher?
Yes.
Manning?
Yes.
Passes.
Okay. So now we're on to B, adoption of parameters of state bar role, rate, access to justice, access to the legal system. Donna.
Good afternoon, Madam Chair and members. I'm going to start once again by showing you something with which you are very familiar. At the board's January planning session, one of the panels that you held was a panel that was facilitated by Justice Lori Zelon and Selena Copeland, at which the board discussed the bar's mission to support efforts for greater access to the legal system. The goal of that discussion on that panel was to think about how to define or set the framework for the bar's role in access to justice issues. This is a reminder of what the old goal 4 was, but we now have a new goal 4. Obviously, access is a very broad topic. And as we've been examining the appropriate role of the bar in supporting access as part of the exercise of our regulatory functions, we have, as we have in many other areas, been looking at what is the appropriate role of the state bar. Where is it that we are uniquely situated to act? Where will our efforts be the most effective and help yield the most change? I've raised that because as I started that sentence, I pointed out that access to justice issues and access to the legal system is an incredibly broad concept. And none of us are elevating any particular part over the rest. It's important to understand that as we lay out the bar's framework for access, it is in no way suggesting that access issues that fall outside of that framework or outside of the parameters that the board sets are any less important. Rather, what we're proposing is that issues that fall outside of those parameters, there are others that may be more appropriate to address those issues, or those issues are more attenuated from the bar's regulatory, licensing, and disciplinary functions. So just as a reminder, I have projected for you the current strategic plan objectives which relate to access. Most of these are already in progress. At least one of them is completed, I'm happy to say. But these are access objectives. Briefly, increasing funding for legal aid, implementing improved approaches to increasing access to justice, updating our lawyer referral service rules, studying the online delivery of legal services, conducting a justice gap study, and exploring increased access through the licensing of paraprofessionals. So how do we put parameters around what the board's and the bar's role would be? We're proposing the following framework. And the wording can use some help, but I'm not asking you to do that right now. The framework would have the bar's role be engaging in efforts to achieve the following: increasing or improving access to legal representation, increasing or improving access to legal services other than representation, or increasing or improving access to alternatives to legal representation. I'm going to go through a little bit of what that would mean under each of those categories, and then types of things that maybe would fall outside of those parameters of where we're recommending the State Bar focus its efforts, where we can be most impactful. So looking at increasing or improving access to legal representation. The types of things that would be included, and there's also a chart on page 3 of your agenda item, if that was a sort of better layout for you, that made more sense. But again, increasing or improving access to legal representation could include issues that look at funding for legal services entities, i.e. IOLTA funding, Equal Access Fund, Justice Gap Fund, dealing with issues, projects, objectives, statutes, statutory changes on any of those topics, regulations or law changes about encouraging unbundled legal services or limited scope, the issue of loan repayment assistance to encourage greater increased numbers of people going into legal services, legal aid. Pro bono, supporting the pro bono practice program, encouraging pro bono. The special admissions topic that we have tackled in the recent past, looking at military spouse rules, the registered in-house counsel, registered legal aid attorneys. Civil Gideon, providing attorneys in civil matters. Incubator programs that would, again, sort of help lawyers to be able to provide legal services, to provide access in underrepresented areas, in our attorney deserts, things that would increase access to legal service, to legal representation. Looking at the sort of the second bullet of our framework, increasing or improving access to legal services, so not representation, but legal services. That would include things like funding self-help, training that we provide for self-help providers, the practical training of law students program, collaborations on providing legal services for veterans through various legal aid organizations throughout the state, our disaster relief efforts that we engage in. Those are types of things that would fall under that category. And then the final category, which is increasing or improving access to sort of alternatives to legal services or legal representation. The exploration of the use of paraprofessionals, which is one of our current strategic plan objectives. Increasing access through technology. Regulating technology or business is part of the discussion that's going on with our ADLS task force right now. And I did not mean to still include the practical training of law students on that. So those are the types of things that would be included in this framework that we're proposing. So then what's outside of the framework? I think it's important to sort of have this discussion to understand what we are saying would be areas that that the bar would not engage in, that are not the place where the bar is uniquely situated to affect change. There are others who are in a better position to affect change in these areas. So that would be things like court interpreters or other language issues, court reporters or other avenues to perfect a record, court funding issues. Access standards for administrative agencies is one of the issues we've talked about with our with the California Commission on Access to Justice, where one of the things that they looked at were physical location, accessibility, hours of operation, counter clerk hours, and things like that for administrative agencies. That would be an area that we wouldn't be involved in. Again, I would emphasize that this is not to say that these are not important issues. They are critically important access issues. Personally, I spent a number of years working on language access in the courts, helped develop the court strategic plan for language access and staff their implementation committee of their language access plan. So these are all issues that I think we would all identify as incredibly important issues when it comes to access. There are countless issues that are incredibly important when it comes to access, but figuring out what sort of the appropriate purview of the bar is, where we should step in and where we should sort of direct our efforts is an important consideration. And so we've laid out this framework for you. I'm not asking that you adopt the framework right now. What our resolution would provide is that staff, in partnership with the chair and the vice chair of this committee, would seek feedback from the Access Commission and the Access community about this framework for state bar involvement in access issues, and then ultimately we would bring this back to you and back to the full board for adoption at the May meeting.
Any questions on that or any comments? Ruben?
Move the recommendation.
Ruben first.
I would second that with just correcting maybe two things, Donna. One of them was you said seeking feedback from the Access Commission and the Access community. The resolution as written only refers to the Access community. I don't know whether we need to call out the Access Commission for your purposes. And then the second one is just a typographical area. We're not going to brine it. We're going to bring it. Yeah. Make sure to invite me, please.
Okay, we have a motion by Alan, a second by Ruben.
The question for staff is whether we need to include the Access Commission in the resolution.
I think I would certainly be comfortable adding that to the resolution.
I think the Access Commission is part of the Access community, but I don't object to it being included.
Can I have a question? I have a question. Yes. I just want to make sure, because then you have under the issue, you have the Veterans Legal Services and all that. I just want to make sure that we do also have the immigrant rights in here. Is that's part of the whole legal, or this, because it's very important at this time also.
Yeah, I would see that as falling under any of those three parameters: issues of legal representation, issues of legal services, legal aid for that issue or that community, as well as alternatives to legal representation or legal services technology to provide access to justice.
Okay, anything else? Any more comments, questions? So the question is, Alan's moved with amendments. Second, and everybody knows what we're voting on? Is there any concern with using the last roll call? Unless anyone has some objections? Okay, we're all here. Okay, that moves on. We can move on then. That's fast. So now we're on, item C, approval of distribution of bank grant funds. Helen.
Good afternoon, everyone. We are here to seek your approval for the distribution of the bank grant funds from 2020 to 2022. I've asked Duan Nguyen, who is the key staff person that staffs the Legal Services Trust Fund and this subcommittee, to present the history and the background and why this is coming before the Board of Trustees for the vote.
Good afternoon, everyone. Thank you so much for having me. I work with Helen in the Office of Access and Inclusion. And for those of you who don't know me, I'm a program supervisor. My name is Duan Wing, and I'm very pleased to be here today. Before we get to kind of the specifics of the proposal, I'd like to, as Helen said, provide you a little bit of context on the bank grants and how the Legal Services Trust Fund Commission came to assume responsibility of the bank grant funds. In 2015 and 2016, the State Bar received approximately $51 million through national bank settlements from between the United States Department of Justice and Citi and Bank of America. And we received those funds through a couple distributions in 2015 and 2016. The funds went it was distributed to every state distribute to every state that had a program that administer interest on lawyer trust accounts, and these are our IOLTA accounts that we administer at the State Bar. The settlement agreements required specifically that the funds had to be distributed to legal aid organizations for this specific provision of foreclosure prevention legal assistance and community redevelopment legal assistance. Because the Legal Services Trust Fund program was administering and continues to administer the IOLTA grants. In 2015, they assumed responsibility for the administration of these bank grant settlement funds. And to date, approximately $41 million of the $51 million has been allocated through 4 rounds of distribution. We have approximately $10 million left from the bank settlement funds. The proposal today that's coming before you is to distribute 6.5 of that approximately $11 million that's left, leaving a balance of about $4 million left for future distribution. Again, the settlement agreement required that the funds must be to support foreclosure prevention legal assistance and community redevelopment legal assistance, but it didn't provide much guidance beyond that, and it didn't provide for a specific definition of what foreclosure prevention legal assistance and community redevelopment legal assistance meant. The Legal Services Trust Fund Commission, assuming responsibility of the administration of these grants, carved out kind of the parameters of all of the funding. They set kind of the time period when funds would be distributed, how much would be distributed. They set the priorities. They also defined what foreclosure prevention and community redevelopment legal assistance is. For foreclosure prevention, they took the very kind of traditional definition of foreclosure prevention, loan modification, reverse mortgages, etc. With community redevelopment, they opted to adopt a very broad definition of community redevelopment, like many of the other states that accepted these funds did. And for community redevelopment, they required projects to support and promote the economic development by providing legal services that revitalize communities. The services had to be tied to broader systemic work that benefits the community, and generally they didn't fund direct legal services unless the direct legal services was attached to kind of a broader systemic approach to the legal issue. The bank settlement awards did not require that the funding be distributed to IOLTA-funded programs specifically, but the Legal Services Trust Fund Commission at the time thought that in order to improve oversight, ensure oversight, and also to reduce administrative costs, that they limited the funding to existing IOLTA-funded organizations. The Legal Services Trust Fund Commission also, in 2016 and 2017, underwent a 1-year planning period where they distributed planning grants to programs that wanted to participate in the program. In addition, they also convened several statewide meetings, sent out surveys, engaged the community, and the legal services community also advocated for certain approaches of how the grants would be distributed. At the end of that 1-year planning period, the Trust Fund Commission did decide, based on a lot of community feedback and engagement, they would set aside $6.5 million for statewide and regional collaborations on foreclosure prevention and community redevelopment legal assistance. And as a result of the Appendix I review process and the board's decision that discretionary funds would need to be approved by the Board of Trustees, the remainder of the funds are now coming to you for approval. So as I mentioned, we have about $10 million left. The Legal Services Trust Fund Commission would like to request your approval for the distribution of 6.5 of that $10 million to go out for statewide and regional collaborations related to community redevelopment and foreclosure prevention legal assistance. And I'll go through a little bit of the proposal. They would be 3-year grants that would start January 2020 and conclude December 2022. They would be distributed through a competitive RFP process. Again, it would only go to existing IOLTA funded programs. However, like in previous distributions, we would allow non-IOLTA funded programs to be sub-grantees of these collaborations. Again, they must be collaborative projects, so it must include at least one organization in addition to the eligible applicant. There are also funding caps that are outlined in the materials that you have. And again, the services must be statewide or regional, and there's a specific definition of what statewide and regional is that's included in your materials. And again, if this proposal is approved, there will be approximately $4 million left for future distribution. So I'll stop there, and I'm happy to answer any questions or.
Yeah, Joanna?
What's the thinking behind limiting it to IOLTA-funded organizations only?
The Legal Services Trust Fund program of Legal Services Trust Fund Commission thought that there was already an infrastructure built in with our monitoring visits of the current grant distribution for IOLTA that they could just integrate it with the bank settlement. And so they thought that it would lower administrative costs and ensure, since there was already a good system for oversight for our current grantees, the IOLTA funded programs.
Administrative costs on our part or the grantees' part?
On our part. And so there would be more money left over to distribute because the administrative costs would be lower.
Do we know what organizations we might be excluding if we do that?
I don't know off the top of my hand. I know anecdotally there are probably a handful of programs that did call me during that period to see if they were eligible, and because they weren't a current IOLTA grantee, I had to let them know that they couldn't apply directly for funding, but I did direct them to the list of 90-something programs that we fund and said they could be eligible as some grantee if they partnered with a project at the time.
Alan? I'm sorry.
So far as you understand what happened at the Legal Services Trust Fund Commission and its deliberations, was there any attempt to determine whether the potential recipients, non-IOLTA, would be worthy recipients, or was the decision made solely on the, or primarily on the fact of the overhead cost?
From my understanding, there wasn't a concerted effort to reach out to see kind of the impact on non-IOLTA recipients. It was mainly due to the oversight and reducing the administrative costs.
Jason? And then Sonia. I mean, Josh, I'm sorry.
So I just want to make sure I'm understanding. So the money that has already gone out did not come to the board. That was going just through the legal trust.
Yes, that's correct.
So I love accountability, but with accountability comes a lot of other questions.
Yes.
And so what I'm trying to understand is when I look at the RFP, it has the need for data collection and status reports. Do we have any idea how the money was spent before? We're coming in kind of midstream here, and whether or not it was effective and whether or not the intent is to go back out to the same folks again with more money, because I would hate to do that if it's not effective.
We've always required, since the first round of distribution, reports, semi-annual and annual reports, the data collection. For this round, I imagine it would be very similar unless we decide to change it. We have aggregated some of that data, and that information was used in our 2019 impact report. And when the Bank Grant Committee, a subcommittee of the Legal Services Trust Fund Commission, reviews applications for future funding, they review it in conjunction with the evaluations in the past.
And are you aware of any past issues with any grantees under the program?
There have been some issues. Like I said, we go out and we do monitoring visits for our IALTA program. We roll in the bank grants as part of our monitoring visit, and with the we require grantees to submit semi-annual and annual reports. And in those reports, we have uncovered some instances. I would say not large occurrences, but some instances that the project wasn't using the money for its intended purposes. And in those instances, we have asked for the funds to be returned. I would say it's a very rare occasion. Of the 100 and I believe 70-something projects that we've funded, that happened in 2 instances, and not for the full amount.
And just to clarify, the monitoring that the State Bar staff does is dictated by the statute as well as the Legal Services Trust Fund rules and regulations. So we are bounded by the guidelines that we have. And so based on those guidelines, when we find instances of non-compliance, we do notify the grantee and we make recommendations on how to rectify those issues, not only in program, but in financial organizational management.
In the State Bar, also from a staff level, are they involved in the decision-making on the RFP? Are they part of the panel, or who makes that decision on grantees?
The State Bar staff, is that what?
Yeah.
Who makes the decision on RFP?
On who gets the grant awards,
the
the
recipients.
recipients. So there's a subcommittee of the Legal Services Trust Fund Commission called the Bank Grants Committee. They've been comprised between 6 and 8 of the commission members, and they break out into working groups to review the RFP. And the commissioners are the ones who review the RFP.
Staff don't have any vote, but they do provide context for past performance as well as up-to-date feedback on timely reporting and organizational performance.
I'm a little less concerned about the need or the desire to have IALTA-funded organizations, but I do think it would be worth encouraging as sub-recipients non-IALTA, because I think we would add a breadth that we don't usually have. And maybe have an effect that's larger than what we've had so far.
Do you think, Josh, or do you mean to encourage it by, for example, the way the RFPs would be scored?
That would be one mechanism to do it, would be to weigh it accordingly.
Mm-hmm. What I just wanted to offer to the committee is this funding, as Dwan outlined, has been sort of predetermined by the commission in terms of how it would go out. But there is this undesignated balance of $4 million that the committee will, I think, have the opportunity to weigh in on early on as to how you might like to see it go out, what kind of criteria might be used. So that's just something to consider with respect to this tranche versus the next one coming up.
Lee, I appreciate that. I do think, however, no matter how baked the idea is, the fact that they're asking us to take an action on it brings accountability to us. And I think we have an obligation to raise issues if we see them. I'm not suggesting we do, but no matter how far along it is.
Ruben?
You mentioned that there are 90-something IALTA-funded grantees.
They fluctuate between 95 and 98. I believe for 2019, we have 97 organizations.
Do you have any sense of how many of those organizations engage in community redevelopment activity?
For this current year, we have at least, I believe, 71 organizations receiving bank grants. Of that, I would say at least 2/3 have received a community redevelopment grant. I can get you the exact number, but I don't have them at my fingertips.
I just wanted a sense of the proportion, so that's
There's been a decrease in foreclosure work, so there's been many more community redevelopment projects that have been requested and funded in the last few years.
Question I have, Sonia?
How many now in existence do we have of the sub-grantees? And when you said that we usually go to the IALTA eligible or organizations, did this sub-grantee incur administrative charges that were also passed on to us in the process? Because, so that's my question is how many now in existence do you have of the non-IOLTA applicants who are eligible and worthy of this, of the funds?
So I can't predict how many sub-grantees from non-IOLTA programs will apply for this upcoming RFP. I know for this current, this year, of the 70-something projects that are funded, there are many partnerships. I would say, off the top of my head, but just anecdotally, there probably is just a handful that are non-IOLTA funded programs that are sub-grantees, though there are a lot of partnerships. So there are sub-grantees from other IOLTA organizations, and that is probably more frequent than sub-grantees from non-IOLTA funded organizations. And I think you had a second part of that question about.
So when you say that you're not doing that because it has to go through and they are vetted already, the IOLTA, the sub-grantees, do they incur admin charges also that would have been passed on to any of the grants?
I guess I'm not understanding the.
So if I can clarify, the DOJ bank settlement limited the administrative costs for the IOLTA distributor as capped. And so we don't limit the grantees' administrative costs. They have a breakdown based on personnel and non-personnel that is already dictated, but the cap is as to the state bar, not to the grantees.
Okay. Yeah, and just to clarify, the bank settlement agreement allows for the state bar to incur administrative costs. Like Helen mentioned, with the RFPs, the projects, they have a budget proposal. Within that, then many of the proposals had administrative costs that then when the commission reviews the application, they will make a determination if they are awarded, if that administrative cost is reasonable or not.
Yeah, Helen?
And also to clarify, if the Board of Trustees would like to make a recommendation on this request about weighing more non-IOLTA collaborations for the review and the rubric, in the RFP currently there is no written rubric for weighting. And so that would be a direction that the Board of Trustees would have to make so that the Legal Services Trust Fund Commission could then execute that.
Yeah, I mean, I think that's, number one, I don't think we have enough information specifically to how it's been run so far. I'm a little uncomfortable with where we sit, to be honest with you. You're asking us kind of blank check to give $6.5 million, which they already have and they've used in the past, but with only so much information. And so we're really standing here as accountable but not accountable, and it's an uncomfortable situation. I understand Leah's point about money coming in later, and we'll have a little more guidance and a little more history on how it's spent. But what I don't want to be is in a position in 6 months from now and have people say that you followed down a road that was maybe not as successful as it could have been. And it sounds like you guys at staff level have reviewed this and are comfortable with where it is, and I guess we just have to rely on that. But in the future, with this type of money, I think a report of how the money was spent would be a little more useful for us in deciding whether to continue down the same path.
I think, Josh, if the committee is so inclined, I think it would be very appropriate to approve with the modification that the commission or staff must develop a scoring rubric, and that it would include additional or enhanced weighting for proposals that include a non-IOLTA subgrantee. It is unusual to do RFPs with no scoring rubric, and that's something, or a sort of a matrix that's transparent to all as to how their proposals will be scored. That's something that came up during the stakeholder process, and it is, I believe, on the to-do list anyway, just in general, to increase transparency. So I think that would be a fine direction for the committee to make.
I would just say, Leah, I mean, look, I do agree with you. Without a scoring rubric, it's impossible to see whether or not this is consistent with the goals of the state bar. And so it is difficult, but nevertheless, I'm also not inclined to maybe express exactly what that rubric should be or how things should be weighted at this point, because I don't think I have enough information to do that.
Sean?
So following up on Leah's idea, maybe we should ask the commission to prepare the rubric and bring it back to the board for discussion.
Was that a motion?
Do we need to have a motion?
So it'll be, yes, it'll be a motion to adopt the staff proposed resolution with that additional direction. So the rubric, the scoring, so it should be, there'll be another paragraph that the commission shall develop a scoring rubric and present it to the board for approval.
And this is a rubric for future funding request or for this one?
I think for this one.
Okay, that's fine with me.
Can we make it to the committee instead of the board? That way, we could do it by phone call if we need.
Thank you. I meant this body, so I misspoke. Thank you.
Yeah, let's come back to the committee. Does everybody understand? Go ahead. You got some more? Anything else?
Before you take the vote, I just want to note that I'm recused due to a conflict.
So noted. Okay, call the roll. Unless there's any question anybody has, unless somebody has, oh, we need to call the roll because he recused himself. Call the roll.
Broughton?
Hmm?
Dellin?
Hold on a minute.
What?
The second resolution, does that include it?
Okay.
Need to add a third.
Do you need to read the addition again?
Yeah,
Sure.
I think.
So third paragraph.
Develop a rubric and report, a scoring rubric and report back to the programs committee.
You shall develop and present it to the board for discussion and approval.
So who?
Sorry, the committee. Thank you, Joanna. Friendly amendment.
Brick. I don't know how to spell rubric. So the legal services. Scoring rubric.
For review and approval by the programs committee.
Okay, so I have a question for staff. If we do not approve the distribution today and ask for the rubric and for it to come back, process-wise, where does that leave you?
It does make it difficult for our department. Obviously, we know that's your decision. We have a kind of a timeline built in that we were hoping to release the RFP next week and having it due back in a month. And then the commission would then have the summer months to review the RFP. If we delay it, obviously, we can and we'll adjust our schedule if it needs to go before the committee again. But that was our hope.
So is that what you were?
Yeah, I was asking, process-wise, what is it, is there a delay process-wise as to what happens if we delay this decision today until later? Because it sounds like some of this is, was already very well developed and pretty far along in the process. So,
Well, the projects were to start January of 2020. It is only
okay.
mid-March, so I feel like we should be able to, especially if the committee is willing to reconvene by phone, to review the matrix, the rubric.
Okay.
So I thought the question was, are we not really approving the first two resolves right now, only the third one on the rubric?
Yeah, I think that's what the question is. I think that's where we are now. I just wondered if we don't, what it is, what the impact is. Okay.
Right. That was my intention that, so we approve the structure of the program as described, and we're just asking the commission to come back to us with a scoring rubric. to address Josh's concerns and the concerns of others. But is that, if that's not doable, maybe we should.
Can I also add,
that.
so there wasn't a formal rubric that was used in the last few rounds, but I did produce a rubric as a guide. So I have something at my fingertips. If you wanted it formalized, I can certainly call a bank grant committee meeting and have them officially adopt it and then present it to you, but it wouldn't be a heavy lifting on our part. And it's based on actually the criteria that's outlined already in the RFP. So if you go to that, you'll see those criteria. We can always adjust to weigh things more heavily or not, depending on what you feel is important. But I do have a rubric that's been created.
With respect to the rubric and the weighing, I'm wondering if the committee has any interest in discussing removing the IELTA-funded grantee aspect of it. In other words, open it up to anybody who provides these services. I know that you still need to have a rubric, but there wouldn't necessarily have to be a weighing whether you have a sub-grantee who's non-IELTA or not. And I know that staff mentioned that there were issues about efficiencies and costs in the administration. I just don't know what that number is and whether that outweighs opening it up to other entities who could provide these services.
Sean?
So what, Ruben, I'm with you on that, to be candid. I think given how far along the process is, what I would, my tentative view, and I'm open to being convinced otherwise, is that we go ahead with the Commission's recommendation to limit the grantees to IELTA. I think perhaps in connection with the rubrics, based on the discussion here, that we might ask them to include some criteria about subgrantees in the rubric, so that if there are new entities or entities that are not IELTA qualified at this point, they get fair consideration. So even if we wouldn't, even if we're writing on a blank tablet, if we might do it differently, I think we might stick with their general structure. And then we do have another tranche of money coming back that the board will have or the committee will have a fresh ability to opine on.
Okay, so
So if I could make sure I understand Sean's point, are we saying that we would incentivize non-IELTA funded organizations, partnerships, collaborations by more heavily weighting applicants who do that? And would the commission be open to that, I guess, is the question.
Well, I think what we should do is staff should report back to the bank grant subcommittee this conversation, and that there was an interest in, first of all, formalizing a rubric, and in considering ways that partnerships with non-IELTA organizations might be incentivized through the rubric. And let's give them some space to kind of figure out what that might look like, bring something back, and understanding the need to turn this around relatively quickly. The committee can be responsive to a request for a phone meeting, really dependent on when staff is able to pull the subcommittee together and get something to you to present.
So does it make sense to hold off on any resolution at this time then? And then once we can get more information back from the commission, then we can address this entirety?
I think so, or else just the last resolution, which is we'd like to see a scoring rubric and bring it back to the committee.
Do we need a resolution for that, though? I'm thinking
think so.
if you're going to report back to the commission, and I would definitely, more than just partnering, I would like them to know that we would like to see non-IELTA organizations be considered in any way that makes sense. I mean, if it means eliminating the IELTA requirement, and I'd like to hear back on that. If they feel it's absolutely necessary, then to do the partnership. But I don't want to limit it to just partnerships. I want them to think about opening it up beyond that as well. But again, it's just reporting back, so I don't think we need a resolution.
Okay. Sean?
Joanna, can I just, so now I'm just want to clarify your thinking. So, because if we adopt the first two paragraphs, we're authorizing the program to go forward. So my thought is if you want to ask the commission to develop the rubric and discuss it with the board and with the committee and have the committee approve it. I think we do need the last paragraph, but I might be missing something that you have in mind.
I don't think we need a resolution if we're asking them to address this and come back to us. We can approve it at that time.
So you would defer the whole?
Yes.
Okay, until the conference call
Yes.
meeting. Okay, understood.
But you still have a motion, Sean. You could, of course, withdraw it.
That sounds like the sense of the committee. Let me withdraw the motion and see if anyone else would care to make another motion.
Just so I'm clear, would you be withdrawing the first two resolutions then? So we would not be moving forward with the distribution plan and holding everything off until the rubric? Okay.
So we're just, to clarify, just taking no action because the sense of the committee is they want to consider it a further conference call. So it's not being rejected or approved.
So they're like the committee would like from the commission a formal rubric incentivizing non-IOLTA organizations, further documentation and explanation about not opening up or including direct grantees that are non-IOLTA, but prior to this RFP, if that's clear, those two items.
We can convene a special meeting of the committee with relative ease, so it doesn't have to wait until our July meeting.
Okay.
Yeah, we can do that. We can do it fairly quickly, I think. No. That's if we do this. Okay, so I think we're clear now. We can move on to item D. I think we're have someone who wants to give public testimony.
We are reaching out to Judge Holly Fougier, the chair of the Council on Access and Fairness. I'd like to give her the opportunity, if she's still at the number we have, to speak first because she is, her jury is due back. And so I want to defer to letting her present.
This is Judge Holly Fougier. Please leave a message after the tone. Thank you.
Record your message at the tone. When you are finished, hang up or press pound for more options.
Okay, hello, Judge Fougier. This is the Programs Committee for the State Bar, and we wanted to hear your comments on COAF. So we're going to go ahead and get started. So hopefully you can call in before we're done. Okay, Donna.
Good afternoon once again. I'm going to do my best not to repeat things I've already said 2 or 3 times this afternoon. Following the various discussions that the board has had, there was an update to the Programs Committee in November, an in-depth discussion about the work that the Council on Access and Fairness has performed. That was followed by an in-depth planning session at the January board meeting, where we explored options for the bar's engagement on diversity and inclusion efforts going forward. The board, as you know, better than anyone else, adopted 9 concrete diversity and inclusion objectives to be added to the State Bar's 2017 to 2022 strategic plan. After the board adopted those 9 objectives, staff met with the Council on Access and Fairness to develop a work plan. The work plan is designed to implement the strategic plan objectives that were set by the board, and we are seeking the committee's adoption of a work plan for the Council on Access and Fairness. Your agenda item includes 2 attachments. Attachment A contains the draft work plan and proposed charge that the Council on Access and Fairness developed at their March meeting. Attachment B reflects revisions to that work plan as proposed by staff. Staff's recommendations are intended to effectuate what we believe the intent of the Board of Trustees was when they adopted the objectives at the January meeting. One of the things that staff considered is the theme of all of the changes that the board was implementing with Appendix I. The board was really looking at elevating the work of the sub-entities to more of a policy body, with staff being the implementer or the administrator of those policies that are developed or recommended by the sub-entity. In the past, the Council on Access and Fairness has assumed much of a, I would say, service-oriented role, and some of the proposals that were included in the COAF work plan sort of continue to focus their efforts as a service-oriented role. And so the staff recommendation is to focus the work more on that policy level, sort of developing the policy and having staff administer or implement that policy. Also, as we discussed with item A on your agenda, there was difference of opinion from the Council on Access and Fairness and staff vis-a-vis the board's intention about the ongoing role of the State Bar and COAF when it comes to judicial diversity. Staff understood the board direction to be that the Judicial Council would take the lead on judicial diversity efforts going forward, and the State Bar would be in more of a supportive role. To that end, the board adopted an objective that the State Bar would assist the Judicial Council in updating their existing judicial diversity toolkit, which was originally introduced in 2010. The COAF has as we sort of discussed earlier, has a significant concern about the judicial diversity efforts. They believe they have made incredible inroads in the past 10 years in really increasing the diversity of the bench. The statistics certainly suggest that the diversity of the bench has increased significantly in the past. They are concerned that if COAF takes a supportive role and the Judicial Council does not assume the leadership role, then there's nothing for them to support. Nonetheless, as we discussed earlier, the leadership staff's conversations with the Judicial Council indicate their interest in stepping up and taking that leadership role, and that the State Bar would then take a supportive role to the Judicial Council when it comes not just to updating the diversity toolkit, but also sort of doing the work of having workshops and summits where you meet with applicants who are interested in becoming a judge and talking to them about what it involves and how to do the application. These are often, the attendees at these events are often folks who do not have judge role models in their life. And so this is something that COAF has done in the past, and staff considered this as part of the responsibilities that the Judicial Council would take a leadership role on going forward, and COAF, the State Bar through COAF would play a supportive role. Staff is recommending the adoption of the charge and the work plan as set forth in Attachment B, which shows in strikeout and underline the differences between the proposal that was made by the Council on Access and Fairness and the State Bar staff recommendations. In particular, when we shared this with the chair and the vice chair of the Council on Access and Fairness, they, sort of raised the concerns about their role in judicial diversity, and also noted an arguable inconsistency in the in the activity that we added on the last page of Attachment B, which talks about an additional activity with regard to judicial diversity, and that's exploring the Judicial Council interest in conducting regional workshops, summits, and meetings for attorneys interested in exploring judicial positions. I think what is missing there is then, and supporting the Judicial Council in delivering those workshops. The chair and the vice chair of the Council on Access and Fairness were confused about what it would mean to explore that with the Judicial Council when we were just in a supportive role, and it sounded as if that was a leadership activity. So I would propose to amend that piece to say that we would end that clause with "and support the Judicial Council in delivering those programs." I'm happy to take questions on any of the suggested changes.
Thank you, Donna, for that. So you're recommending a change to the staff changes to the commission. So can you just, I want to be sure I understand exactly where the change is.
Yeah. So looking at attachment B, the very last page of that agenda item.
Yes.
The second, the first bullet that shows on that last page that says explore Judicial Council interest in conducting regional workshops /summits /meetings for attorneys interested in exploring judicial positions.
Okay.
I would append to the end of that and support the Judicial Council in delivering such programs. Part of the idea here, and Leah and I had a conversation with Judge Kevin Brazil, who presented to all of you as part of the January planning session, and who is the chair of the Judicial Council's ad hoc working group on updating the Judicial Diversity Toolkit, and co-chair of their Committee on Providing Access and Fairness. We talked about the notion of having regional summits. There are a lot of these kinds of workshops that happen in the Bay Area and happen in Los Angeles. The Los Angeles Superior Court, as Judge Brazil explained to you when he was presenting, itself has very strong programs. And we talked about the need to get these programs out to more rural areas, other areas in the state, other than the Bay Area and Los Angeles. And so we talked about the idea of doing some regional summits, and that would be something that together the bar and the Judicial Council could participate in to make sure to provide these same services to attorneys who really don't have who haven't had these opportunities in the past and may not have role models who are judges.
So when you say support, are we clear on how we are going to be supporting?
So we don't have a pure definition of support. Support may be providing some financial resources, but it's certainly not taking the lead in setting these up and delivering all of the presentations. It might be attending and participating in the delivery of information to the attorneys and providing some of the if there's mentoring that is happening at these workshops. Certainly we would work that out in discussions with the Judicial Council, but it would be clear in our vision that the Judicial Council would take the lead in these, or the Judicial Council and the courts, and would take the lead in this. And we also anticipate working with local bar associations at these kinds of events and really having them help get the word out and find locations. And ideally these would happen at courts in the region. We'd have the local bar associations involved and the affinity bar associations, and making sure that we are getting the best participation possible.
Sean, did you have something?
Great. So first of all, let me go back to big picture. I want to say that the presentations we've had from co-op about their judicial diversity initiatives and work and the results have been very impressive. And so I don't think they should be discouraged by the board's decision to work with the Judicial Council to shift the focus on those efforts to Judicial Council. And I think it's important to just put on the table that if the Judicial Council is communicating to us that they intend to take the lead on that, I think we need to take that on faith that they are going to do that. And I have every expectation that will happen. So, speaking for me, I support these initiatives. And I don't think co-op should take any other message away from this, a negative message about their work. So that's big picture point. Smaller point is I have a question about another aspect of the table. So this would be in your appendix B on the second page, goal 4, objective I. Okay. So there's a deletion of providing implicit bias training for bar exam readers and pre-testers. Are we doing that in some other way?
Yes.
Okay.
Yes,
So if you
thank
could
you.
just elaborate on that.
Thank you for asking that question. Elsewhere in the document, or actually it was in the charge, which appears on the page prior to that, one of the items that we propose taking out of the charge is the delivery of implicit bias training to the sub-entities and the state bar staff. The agenda item talks about this a little bit. The plan is that the state bar is going to be, we engaged a professional trainer to train all staff in 2018. We plan to continue that to ensure consistent delivery of the training. Historically, COAF has provided training to Jenny, and we want to roll out training to all of the sub-entities. We are going to be working also to develop an online training module, ultimately that can be delivered to all of the sub-entities, and we would roll training to the same group of the pre-testers and the graders out through that process. So we absolutely agree that it's an important thing to do. It's just not something that COAF would be doing. This sort of goes to that issue of service delivery as opposed to setting the policy of it's incredibly important to do this. Staff will administer through bringing in of professional trainers and ultimately an e-learning module will deliver the training.
Okay, good. Thank you.
On that point, will COAF look over the curriculum or anything? Will we have them involved in any way and sort of looking over the curriculum and saying, could you add that, there's something that they may see that they think should be included? Are they going to be involved in any way along those lines?
Certainly their involvement in looking over that information would be welcomed.
Okay. So they still have some involvement. Joanna?
I'm struggling with how we're taking them out of the service model aspect of it works with having them support the Judicial Council on these summits and so forth. To me, that is a service that you'd be providing. You'd be going there, providing different services with the Judicial Council. I'm not saying we shouldn't do it, but I really am worried that we're not being consistent in the message that sends. So.
I think our hope is to transition our support to a true support role. That is the curriculum, the infrastructure, helping to build the infrastructure between the local courts and the local bar associations. I do think this will have to be a phased in and gradual approach given the history. But that's the intention. So certainly we've talked about using our role as a state bar to, for example, recruit attorneys to attend the summits. We can do that all electronically. The COAF role right now is very much focused on working with the Judicial Council Committee to finalize the toolkit, which is not direct service. So with respect to the regional summits, I do think initially you still may see COAF members really wanting to participate in those. And of course they can and are welcome to in their own stead. I think it will be a bit gradual to transition to more of a true support role as we see the Judicial Council really stepping up in this area. So I agree with you. I think it's a bit of the reality of where we are right now.
Yeah.
In that respect, I think we have to rely heavily on staff and our COAF liaisons to really monitor how things are progressing to make sure we stay in the right lanes.
I think it's more of a bridge. So I think, like she said, it's a gradual process. So it's sort of a bridge as we bridge between what we've been doing and what the Judicial Council will be taking up. So in the meantime, we're still continuing until they really get on board. Any other comments?
Staff's recommendation would be one additional change. Second.
So you're clear on what the change is and the one you proposed about
The
last
change
bullet, yeah.
was on what is now the last bullet on the judicial diversity toolkit objective, appending to the very end of the sentence that's there, and support the Judicial Council in delivering such programs.
Okay. Unless there's any objections to anyone from
I
anyone?
left the room.
Hmm?
I left the room.
Oh, you weren't here for the discussion? Okay, let's call the roll.
Broughton? Dellin? Duran?
Yes.
Lee?
Yes.
Mendoza?
Yes.
Bertula? Selig? Steinbrecher? Manning?
Yes,
Passes.
thank you. All right, so,
Last item, I'll try to get us back on track. So this is the review of the metrics. As you'll recall, our strategic plan directed staff to develop metrics to be used to assess the performance of the entire state bar. We did that, and those were submitted to you at your January meeting. Importantly, that's the first time formally the board has seen or directed staff to develop metrics outside of the discipline system. We've been very focused as an organization, as you know, on OCTC in particular. But we now have the benefit of having metrics that are reflective of the performance of our entire organization. You'll see on the Programs Committee agenda as well as the RAD Committee agenda a specification of those metrics associated with the offices under the purview of those respective committees. So here you see the Programs Committee, the attachment A reflects those metrics for all of the offices that ultimately report up to you. In the report, I simply provided information about one of the metrics that where we did not meet our stated performance goal for the first reporting period. The first reporting period is, of course, January of 2019. There's only a few metrics that require monthly reporting. So the overall report, the monthly report, the first one is provided as an attachment to my executive director's report on tomorrow's agenda. So I apologize for this being a bit out of sequence. But in that overall report, you will see that there is one metric under the purview of the Programs Committee where we did not meet our stated performance goal. That has to do with our customer satisfaction levels, the performance for our call center, or as we call it, our resource center staff. I thought this would be a good opportunity to provide you with just some statistics so you can take a look at the volume here. You see that we had in February 16,000 calls in that month handled by our staff. It is a tremendous volume. We have centralized much of our call handling at the state bar, but not all. So I've listed here which areas of the bar that represents. You can see, I think our average handle times and wait times are quite reasonable, but those maximum times are significant, and I'm sure they are driving up our fairly low customer satisfaction levels. As I indicate here, we haven't done any analysis yet to sort of dig into this. We will come back to you with that. I would note that this is really an interesting area. I think several of you have received emails or calls from folks who've been frustrated by a failure of the bar to respond or very delayed responses. I know some of them have come to me from you. And, we strive to provide excellent customer service, but we don't have a large number of staff performing this function. And it is a decision that an organization needs to make about resource allocation. So we've centralized and tried to become more efficient. We have not necessarily added staff. And that will be a conversation that we may need to have at some point as we continue to monitor these metrics. We also haven't invested in sort of a best-of-class CRM type of system that enables you to do chatting and email messaging and really manage your call and incoming volume in more modern ways. Again, decisions that we might have to make as an organization about how we allocate our resources. All that being said, 59% reporting a high level of satisfaction is not dismal, particularly for all of us that have tried calling call centers or credit cards or airlines. 59% isn't terrible. So that's the brief report on the metrics. Any questions? Yes.
We have 4.5 hours. That doesn't seem, it seems like a glitch because the average queue time is not that different. So do we know that everything's actually working the way it's supposed to? And not necessarily with the personnel, but with the actual system?
I believe so. I haven't heard that it's not. As I said, I haven't had the opportunity to work with staff to really dig into this. There were a number of things that did occur. So we closed the resource center for 2 days, one for staff to train on the new Odyssey case management system, another for them to train on the admissions case management system. And so it may be that there was a lack of clarity in our outgoing messaging about the fact that the resource center was closed, and perhaps somebody sat on the phone for 4.5 hours. I'm not sure, but again, we'll look into this a little more closely.
Okay. Yeah, Josh.
I know recently in the last couple of years, if you call an airline, for instance, and there's a long wait, they will give you the option to call them back when someone's open. Do we have that option?
We do, but I have received several complaints about the functioning of that option. So that's something that I will need to look into. We do have it, but I again, some of you know this because you've received the complaints that they left a message to or indicated that they'd like a call back, and it's been 4 days and they haven't had a call back. So that's probably not the best standard.
Sonia?
Do we have in our website where we do info at, where they can leave messages and how many do you get of those and do we respond to them?
Email messages? I believe that we do. Why I'm pausing is I know that we do, though I'm not sure we have one centralized to the resource center. We have those specifically for different areas of the bar. I don't have volume stats for you on that, but I can certainly get those.
Okay. Anything else to come before the committee? Programs Committee is adjourned.
The next item on the agenda is the RAD Committee. We will take a 10-minute break before we begin. All right, let's get going. Attention, attention.
All right.
The ship is sailing. All right, this is the RAD committee meeting. We are starting at 12:22. Please call the roll. Pardon me?
We're just trying to get us back on track, I understand. Because we're gonna go into class right now.
Ready?
Yes.
Broughton? Dillon? Durant?
Here.
LeBrun? Lee? Mendoza?
Here.
Petula?
Here.
Saleh?
Here.
Stalling? Allen?
Yeah. Here.
Okay.
Okay, thank you. We're going immediately into closed session. The closed session should last 20 minutes, but we will say 2:40. Okay? And we're going in pursuant to Government Code Section 11, 26 sub C sub 2.
But you can do.
Oh, yeah, no, Mike's. Alan, I'm leaving you for hands. I'm saying.
You're leaving?
Yeah, I know. I've got it hearing at 3:30, so I've got to go.
Good, I see it. All right. We are in grave danger of running out of my self-imposed time limit to get us back on schedule so that the RAD meeting would end at 3 o'clock. It's now 2:57, so we're going to have to really move this puppy. All right. The RAD committee is now in open session again, and I think, do we need to take the roll again?
Yeah.
Okay, we need to take the roll again.
Broughton? Here. Dellen? Here. Duran? Here. LeBron? Here. Lee? Here. Mendoza? Here. Bertula? Here. Selig? Stallings? Steinbrecher?
Selig has to leave for a court appearance, and he will be not here for the rest of the day. All right, the first item on the agenda is call for public comment. Is there anybody in the room who would like to, any member of the public in the room who would like to make a comment? I see no one. Is there anyone on the telephone attending telephonically who would like to make a public comment? Hearing none, the next item on the agenda is an oral report from the chair. I don't have any particular items to pass, but I have told the interim chief trial counsel, that Melanie Lawrence, that she may spend a little bit of her time making a report on behalf of OCTC. But before we do that, we have a consent agenda. Does anyone desire to remove any item from the consent agenda? Okay. If not, we will deem all 4 items on the consent agenda approved and move on to the business. First item of business, 3A, is an update on the implementation of Odyssey case management system by Hatem Kalek.
Good afternoon. Hatem Kalek, Director for the Office of Research and Institutional Accountability. Wanted to give you just a quick update on the CMS implementation that has been going on for a while. On February 11th, we went live with the Odyssey implementation for the Office of the Chief Trial Counsel, State Bar Court, and Probation. Since then, we've been working closely with the departments to address, typical post-implementation issues with process data, working on some reports. We still have a couple of outstanding items for State Bar Court. In particular, we are working with the vendor to complete the portal, which is the public-facing version of the State Bar Court docket and case search. We're also working with the Office of Chief Trial Counsel on the scanning of active files. And to date, we have scanned roughly about 1,300 active cases into Odyssey. And the work continues pretty much throughout the year until we complete most of, the goal is to complete all the active cases first. And then we'll start addressing closed files after that. Also, on the quick update on the online complaint process, which is also tightly integrated with the case management system. That one, we went online with that in October, and since then we've received roughly about 2,600 complaints. We're averaging about 121 complaints a week coming in online. We have the English version and the Spanish version live, and we're currently in the process of translating to Russian, Korean, Vietnamese, and Chinese. Any questions?
Thank you. Any questions for Hatem? Jason.
Hatem, I didn't want to let this moment pass without recognizing your very diligent work in implementing this fantastic case management system. 4 years ago, when I was on the board, people were talking about our antiquated case management system and how you couldn't do 99% of the things that you were supposed to be able to do. What we now have is a integrated case management system soon that is ingesting online complaints, that has paperless files. and extreme data tracking. So really congratulations to you. I think I've mentioned this a number of times. I've been by your office and seen the gigantic spreadsheets that you have posted up, and really, really well done.
Thank you very much. Appreciate it. Thank you.
Anyone else? Thank you, Hadam. Item 3B has been removed, so we'll move on to item 3C, which is the update on Office of Chief Trial Counsel by the Interim Chief Trial Counsel, Melanie Lawrence, and any other comments you'd like to make.
Thank you. So I want to start by highlighting some things that our office has been involved in the last few months, and I think they're important in particular because they relate primarily to the strategic plan goals of our office. So first of all, one of the strategic plan goals, as you know, is related to the non-attorney unauthorized practice of law cases, and in particular that we forge relationships with law enforcement and develop a coordinated response to this issue. So in doing that, late last year, I sent a letter to all the district attorney's offices in the state of California outlining what our office is able to do to address this issue and how we really need them, the law enforcement agencies, as partners to really be effective in addressing this issue. And what we did thereafter is we targeted some of these offices that we had sent the letters to actually reach out to them and ask for in-person meetings so that we could talk about ways that we could effectively partner with them. So since late last year, up until just recently, we have now met with 12 district attorneys' offices. Our manager and our supervisor of our non-attorney and authorized practice of law unit is going out and meeting with them. We have 8 to 10 others that we've targeted that we want to complete by the end of May. And what we found in doing this is that they're really excited. They're really happy to see us. They didn't know what we do. They didn't know about the tools that we have. And frankly, they didn't really know necessarily about the tools that they have to actually address this issue. So we've been able to talk a little bit about how we can marry our resources to address this issue. Some of these agencies have more resources than others. Some see this problem more prevalent than others. And so we're going to have to tailor our work with each of them accordingly. After we're done with meeting each of the district attorney's offices, we are going to go back and regroup and talk about next steps because it can really seem like a very big project. But we're well on our way to forging these relationships. Related to the non-attorney unauthorized practice of law, I wanted to highlight for you one of the recent cases in our office. A couple of weeks ago, we went into Los Angeles County Superior Court to assume jurisdiction over the practice of a non-attorney by the name of Judith Gill. This is a person who we had referred to law enforcement last year. My understanding is that she is someone that had been on the LA City Attorney's radar screen for some time, but a lot of the complaints that they had become stale, and we had new complaints from new complaining witnesses, new victims. The city attorney's office and the Department of Consumer Resources was able to actually go in and do some undercover work, and they were actually able to collect some evidence that allowed them to actually bring charges against Ms. Gill. And then we went in to assume jurisdiction over the practice. Like I said, we did that about a couple of weeks ago. There were multiple locations that she had. It was quite an effort. It took our whole team many, many hours of work to go in. These were actually residences where people were continuing to meet with these clients. This was an immigration practice. And so we actually went in and seized the files. We are still inventorying files, and we imagine that there's going to be over 1,000 of them. One of the troubling things that we've found in the files is that there are a number of work permits related to these victims. And the problem that we have is that there are only the names of the people, and there's no contact information. The addresses were simply the address of Ms. Judith Gill. So we're actually going to be having communications issue a press release letting people know that we have work permits so that we can get those back to people. So you can see how this is a very resource-intensive initiative.
And, again, this is a team that is working diligently. We have about 12 people, and these are people that are not working on our regular cases that we deal with every day, but clearly it's a need, and we're doing what we can to address the issue. I also wanted to highlight for you that related to the strategic plan goal about improving operational management, my office this year in January and then this last week actually have met 2 times as a management team to work on goals planning for the year. I've been in management in the office since 2012, and I can tell you that we've never, ever done that as a management team. And so my management team actually sat down with the strategic plan goals, and we talked about how we can meet those and integrate them into our culture. And so we are now setting forth to do that. In addition, what we've seen from some of the staff surveys that have been done in the last couple of months, we know that staff is particularly concerned about supervisor and manager development. So that's something that we're going to be working on this year, including that next week we are starting a 5-module series in which all of the supervisors and managers will be working on development. So that's what we'll be doing throughout the rest of the year. So those are some highlights in our office in the last couple of months. And Alan, I don't know if you want me to also talk about training at this time, or you want me to do that later? Okay, sure. So Alan and Sean had asked me to give you a briefing on where we are with our training program. And I want to take you back for a moment to prior to about 2013. The office really didn't have much in the way of a formalized training program. It was sort of ad hoc when we had new staff come in. And around 2013, what we did was we put together a training unit. And what that was one unit where attorneys who came in new were assigned to. They had the same supervisor, and they were to be assigned there for a year. And we slowly introduced them to our work. And we treated them, like baby attorneys in the office for the first year. I think it worked well in that I think that we were able to focus on development of individuals. I think what the challenges were that operationally it was challenging because we needed those bodies on teams to be actually doing the work. And it also didn't address the issues related to investigator training. So we moved away from that, and in conjunction with the workforce planning, in 2017, we actually developed a training team. It consists of a senior attorney, also an investigator, 3 in our office, and an admin. The team is managed by the calibration manager, so that the calibration manager is also over the appeals team, which is often where we're going to see training issues when we're looking at trial records, for example. And so what they have been doing in the last year in particular is really working on a robust onboarding program. And that includes that we've made significant efforts to start new staff all at the same time, so sort of classes of staff. That way we can actually employ the training program at various times throughout the year and get everybody in at once. We're doing that with both Los Angeles and San Francisco, so we're having those staff start at the same time, and we're doing training by video conference. The training is on procedural and substantive aspects of our work and practical advocacy skills. We conduct it live with experienced OCTC staff and exposes staff to a broad range of experience and perspectives. The staff gets a binder of information that they're able to take with them, so they have written reference with them. Some of the topics, and there are very, very many of them, it takes us about 6 weeks to get through the entire module. We talk about the different types of cases that we handle and case prioritization, legal advising on investigations, preparing investigation reports, how you make charging decisions, aggravation, mitigation, discovery, conviction, referral matters. So really every aspect of our work. The training unit is also doing regular MCLEs in substantive areas. So we're looking at things that are really meaningful to our work. In 2018, we focused primarily on the new rules of professional conduct. So we actually had 5 two-hour sessions just on the new rules alone. We also have an annual training related to current developments, and this focuses on hearing department decisions and review department decisions so that we can learn from the issues that are coming up and how they're taking shape in the court. And we also incorporate sort of a lessons learned training so that we can take lessons from our trial records, for example, or other issues that have come up over the year. And those are the time for us to talk about them and train staff on them. We also do bring in outside folks, experts, to do training. So in the last couple of years, in the last year in particular, we had someone from the Contra Costa DA's office who did something on prosecuting a domestic violence case. We also had training on elder abuse cases. We've had training on an overview of non-capital habeas corpus law and bankruptcy and related misconduct, to just name a few. And these are all important because the reality is, as cases come to us, we have to recognize and at least have a familiarity with these issues because we might be investigating a case related to probate, which may bring in elder abuse, for example. We might have a case related to an inmate who's complaining against a defense attorney, and it might implicate habeas corpus or prosecutorial misconduct. So that's why those are important. In 2019, we anticipate having training related to CPRA, issues in disaster situations related to attorney complaints related to people preying on individuals who are experiencing disasters. That's going to be a co-presentation that we do with the National Insurance Crime Bureau. We also are going to be investigating and prosecuting immigration-related cases and identifying and handling cases when an attorney respondent has a mental disorder. We also, in particular this year, want to focus on practical skills training. I will tell you that last year in particular, our training staff went up to our San Francisco office and had a 3-day training with attorneys and investigators on direct and cross-examination. And I think it was really, really helpful for the staff. I think although they were concerned about it and worried about their own exposure, I think it was a real learning experience, and some of them really got into it. So I think it was really useful. We also brought in last year a retired FBI agent who did training for our investigators related to interview techniques. And also last year, we had full day seminars, writing seminars for both investigators and attorneys. We also regularly do outside training. We send folks to outside training. So, for example, we have sent attorneys to NIDA, both for the trial skills training and deposition training. And we also send our attorneys to the National Organization of Bar Council, which has a twice-a-year meeting where there are substantive issues that are discussed. And also we send our investigators to the Organization of Bar Investigators. Similarly to NOBC, they have substantive issues related to investigating disciplinary cases. We are also fortunate in Los Angeles that the LADA's office extends invitations to us for their Saturday seminars. So I think that's held once a month, and our staff is welcome to go to that. And also the NIDA webinars that are offered are available to our staff. We are hoping that in the next year, as I mentioned, that we are able to focus more on practical skills training. It does take a significant amount of effort and staff effort to put together some of these mock trials, for example, but we think it's really important. I will also tell you that we complement our training by partnering new attorneys and new investigators with mentors. And it's a formal mentor program. The mentors get a letter outlining what their responsibilities are. And for both the attorney and investigator staff, they might include attending first settlement conferences, co-counseling cases, reviewing written work. For investigators, it could be discussing investigation plans or sitting in on witness interviews, et cetera. And they do that formally for at least the first year that our staff is here. So I feel like the training that we've done has really evolved over time. I'm happy that we really do have a robust onboarding program, because that was a real gap for us, and I think that we've now achieved that. And now as we move forward to concentrate on the practical skills training, I think it'll round it out nicely. And that's all I have, unless you have any questions.
Thank you very much. On behalf of Sean and myself, I think what you're doing in training is extremely important and is productive and will be increasingly productive. So you're on the right track. Thank you very much.
Thank you.
Any other questions or comments for the Chief Trial Counsel? All right. Thank you very much. All right. Next is item number 3D, which is a report on the fingerprinting, and that's going to be presented by the Chief of the Mission Advancement and Accountability Division, Dag McLeod. And it is Mr. McLeod. It is the sense of the chair that the board would look with favor on an abbreviated presentation. With that said, please proceed.
Hello. We've just called into Suzanne Grant, Office of the General Counsel. I am here with Carolina Almirante. I think most of you know Carolina better from her capacity as providing you data related to the diversity or lack thereof of the profession in California. Carolina, you may not have known, has been the lead on the implementation of the fingerprinting requirement contained in California Rule of Court 9.9.5. I'm going to move very quickly through this presentation at the request of the chair. I would like to say this at the outset, though. This has been an extremely complex project. It has involved pretty much every division at the bar, and it's been a tremendous team effort. IT is necessary. When you see the numbers of fingerprints that the state bar is receiving and processing, that doesn't happen by individuals actually reviewing that data. It has to come in electronically and be handled in an automated fashion. We cannot do that without IT. The Attorney Regulation and Consumer Resources team has been vigilant in fielding phone calls, providing information, providing reminders to attorneys. The call centers at the front of that, the Office of the General Counsel has been deeply involved in this, Human Resources, and the Office of the Chief Trial Counsel, of course. So with that, now I will move more expeditiously. The mandate was on the first slide. This is contained in the report. This is the number of fingerprints that are coming in, or the number of attorneys who are being fingerprinted each month since July of 2017, but you'll see the red line there, the red vertical line, when California Rule of Court 9.9.5 was adopted. And you can see what a difference a mandate makes. That's when the attorneys really started getting fingerprinted. We're getting about 13,000 fingerprints, attorneys fingerprinted per month. And I keep correcting myself on that because we actually get multiple reports from the Department of Justice. We get an FBI report, and we also get a California State Department of Justice report. And so the number of reports that we get from Department of Justice is at least double the number of attorneys that we are getting fingerprinted, because there are various different ways in which those reports come in. So these are the numbers of attorneys because that's the unit that we're most interested in. Do we have all of our fingerprints in for all of the attorneys who are required to be fingerprinted under 9.9.5? And the short answer is we're getting darn close. We are 2/3 of the way there. We are less than 2/3 of the way to the deadline of December 1st. If you take the 189,000 active licensed attorneys in California as of March 1, simply looking at that 125,000 who have now come into compliance with the new rule of court, that's the 2/3, the 66.2% in compliance. We have 64,000 attorneys who remain to be fingerprinted. Again, I would just point to the interdivisional effort that has been involved in making this happen as the reason why I think we've had a lot of success. There's a lot of messaging going out to the attorney population. I did want to walk through this very quickly. This was an effort. I have thought of this initiative in two big parts. One big part is compliance. We need to get attorneys fingerprinted and in compliance with the rule. The second big part is once they are in compliance, we're getting data that we have not had in the past, and we need to process that data, and we need to have a system for dealing with it. We need to review the rap sheets, determine whether there are charges that attorneys, convictions that attorneys picked up that we weren't previously aware of, and figure out how to deal with those. That's what this table attempts to show, and it's a bit unwieldy. So let me just point out that the total in bold under agency, sort of around the top third of the table there, where it says 6,389. That's the number of attorneys for whom we have received rap sheets out of the 125,000 or so attorneys who have been fingerprinted to date. So that's what that 6,389 is. We're not prioritizing 6,389 rap sheets, however. We are prioritizing based on the following subtractions from that number. So the less, one area that we're not prioritizing is arrests. If it's only an arrest, that's not a top priority. So there are 904 that you subtract from the 6,000. We have a number of rap sheets that have information regarding convictions that were exclusively pre-admission. Exclusively pre-admission convictions are not a priority right now. We have then another number that we're pulling out. The 25 refers to attorneys who are either inactive, dead, not eligible, or resigned. That's a category of attorneys that we will not prioritize. And then the final number there is that we were able to do a match of records in the AS400 of attorneys who have come to our attention already as a result of either a reportable action on a criminal charge or through criminal conviction monitoring. And so those numbers are also the ones that we're not prioritizing. We get down to a number 2,400. We found yet another little batch of convictions. That's the further table. I don't show it here today, but those convictions were convictions on infractions. We've subtracted those out as well. So at the end of the day, we're actually a little below the 2,400 number. We're down to just over 2,000 convictions post-admission on a misdemeanor or a felony. So those are the rap sheets that we're dealing with. We have begun the process of transferring the records to OCTC, and in order to prioritize those, we took 20 felonies. It was the breakdown is about 99% misdemeanors, about 1% felonies. There were 20 felonies. We transferred 20 felonies to the Office of the Chief Trial Counsel, and the Chief Trial Counsel's office is going to be prioritizing those. And I'm going to leave it at that. And if you have any questions prior to Carolina, who's going to talk about sort of the next steps for implementation, I thought maybe I'd pause and give you an opportunity to ask any questions you might have. Under 25-ish.
I figure to be only those which there was some notable conviction or notable...
that there was any record at all. So what the DOJ will send to us, if there is no criminal history in their databases, we'll get a code that says C, they're cleared. If there is a criminal history of some kind, we get a code that says U, for what reason I don't know exactly it's U, but we get a code that says U, and we get a rap sheet that accompanies it. So we get both the count that the attorney has a rap sheet, and we get the rap sheet.
Okay. And
those are the attorneys who have rap sheets.
Do you have to go through those rap sheets by hand, or do you have some sort of mechanism to screen them?
We do not. We have a mechanism, and it was tricky because these are text files. They're big, unwieldy text files. And so it took some time from, I didn't mention Office of Research and Institutional Accountability, which is leading the charge, but in Araya, we had a guy who was able to do some text parsing with code that allowed us to then structure the data in such a way that you can pull out. Here's the charge code. Here's the attorney ID number. Here's the charge level. Is it a misdemeanor or felony? Here's whether it was a conviction or not. So that type of data structuring is what was a rather tricky piece of this.
Just for the record, I've been fingerprinted. However, do you anticipate that those that are putting it off maybe towards the end are likely to be the worst offenders?
That's what I like a lot about about trying to project based on this. It could be. I mean, there are all sorts of ways you could speculate about this. I mean, in the report I made a sort of broad assertion that if we simply take the average number of attorneys who are fingerprinted each month and apply that to every month from now forward, we're in total compliance by August. Do we expect the attorneys who are not yet fingerprinted to behave the way that these attorneys fingerprinted? Don't know. That's a good question.
Okay, any other questions for Mr. McLeod? Okay.
So very briefly, So very briefly, the chart that we have here reflects a portion of the notification and penalty schedule that the board approved in 2018, and want to focus on the last set of stages. Since the implementation of the rule in June, we've instructed attorneys on how to come into compliance. That includes sending monthly email reminders, on average of 40,000 emails being sent weekly. So allowing attorneys to at least get a monthly reminder now up to bi-monthly reminders. As part of our current stage, stage 3, we sent out a postcard notification in the mail, so attorneys received a very bright orange postcard indicating that they have to come into compliance with the rule by April 30th to avoid any penalties. We will continue to send notification all the way through all the penalty stages. Our goal is to ensure that attorneys are, that we are accurately identifying who's in compliance, who's not in compliance. And in our AS400 database system, we do have a process to identify who is in compliance and who is not. We're also working on preparation for the penalty stage, which will include information from the AS400 system. And then lastly, with the data that we receive regarding convictions, we recently hired a program coordinator and offered the position that she's accepted, and the goal is that she would hopefully start by the end of the month, which will support the data transfer of information into the Odyssey database system, as well as the tracking of arrest information that would result in charge that would then be transferred to OCTC. Again, she will be starting at the end of the month and will be supporting much of that data transfer of conviction information. Any questions?
Okay, thank you very much. Any questions on this topic? Okay, thank you very much. Appreciate it.
Thank you.
Thanks for all the hard work. Big job. All right. CE, 3E. Yeah, 3E. Yep.
All right. So here we have the metrics again. Those of you also on the programs committee, this is a very similar format where I have provided those metrics that are applicable to RAD as a separate attachment. In addition, I have pointed out in the memo or in the agenda item, not those metrics where we did not meet our performance targets for the month as I did in the programs committee agenda item, but instead 2 metrics under RAD purview that I believe warrant additional discussion. As these were rolled out in January, and I indicated at that time, and then also in this agenda item and the other similar items you'll find throughout the March agendas, the metrics need to be viewed, I think, as an iterative process. We will have to be continuously improving them as we implement them, and I think that's appropriate. So there are 2 that I'd like to have some discussion about today, and Melanie, come on up and we can start that. There are 2 metrics that I think need additional definition. One of those is minimize the number of P1 cases in the backlog. Obviously, critically important that we're focused on our priority 1 cases. We don't want to see those in the backlog, but minimize in and of itself is not a helpful term. So we want to talk a little bit about how to define that. Similarly, another metric is maintain the level of crew reopens for reasons other than new evidence. So CREW is our OGC second look unit. This is a performance metric for OCTC because you don't want to see OGC reopening cases that OCTC closed for any reason other than new evidence. But maintain in and of itself doesn't tell you anything. So Melanie and I have discussed some possible options for the committee to consider, and I think I will turn it over to Melanie to walk through what you think about minimizing P1 and maintaining CREW, and I can chime in and we can take it from there.
Sure. Okay, thanks. So related to the P1 inventory, and I think, I don't know if it's on this item, I know that there's another item where the metrics are depicted in table form. Related to the P1 backlog, there are a couple of ways that it could be depicted, but I think that perhaps the most meaningful way is if we consider the P1 inventory not as a whole, but as the cases that we really have control over, which are the active cases. So I think we've talked before that OCTC has an inventory of cases that includes active cases as well as suspended cases. And the suspended cases are there for a variety of reasons, mostly because we expect that the respondent is going to be disbarred in another case that we're pursuing. So we're not going to invest the resources in those suspended cases. Oftentimes, those suspended cases are in the P1 inventory, and they are reported in backlog. For example, when we produce the ADR, they are included in the backlog. But if we're looking at it as a performance metric in terms of how's OCTC doing related to productivity, it doesn't seem reasonable to focus on cases that we don't really have control over. So what we'd like to do is focus on the P1 inventory that is active, that's in backlog, and to consider that in relation to the entirety of the active backlog. So my suggestion is for the metric, one, that we think of it in that way. And then in terms of identifying what should the metric be, one of the challenges that we have at this point in nailing that down is that we only have basically 3 months of data from 2018 as to where we were with the P1 inventory. And that's because we started the prioritization in mid-2018, and it took cleanup to actually convert all of our cases, which were in the other system that we were using, to the new priority system. We didn't really do that completely until around October of 2018. And the problem with using only the data that we have to really define the metric is that we know that our work is on a cycle every year, that it's always in the last quarter of the year that we are doing this backlog push. And while I hope to get away from that, the reality then is that if that's the only data that we're looking at, then it's probably skewed towards the low side. So we really need a full year of data to actually then go back and see what is really a reasonable and useful metric. So in terms of how we identify it, I think it's not going to be reasonably until October of 2019 that we can do it. And then again, I would like to do it focusing only on the active P1 backlog as it relates to the total active backlog.
Any questions for Melanie? Okay. Oh, yes, Mark.
Just a quick one, sorry. I thought I heard Ed talk to us one time about when the person is going through criminal process, that those cases might also be suspended. Would that be an additional category of suspended cases?
If someone is going through criminal proceedings in which we think that the conviction would result in summary disbarment, for example, and we have investigation cases, then we would put those investigation cases in the suspended inventory because we anticipate that that matter is going to result in the disbarment. Yes.
Any other questions?
My only thought is that we do the active to active comparison, but that we do also report on the total backlog to total backlog. So we would have too, because I think it is important that we demonstrate that we are looking at the backlog in its entirety as well, even though I think Melanie's points are perfectly legitimate, but we have been criticized in the past for sort of trying to hide the numbers on the suspended side. So I think we should report both, but use the active to active as the performance metric for sort of accountability purposes.
So, okay, now I'll move on to the crew metric. And yes, it's clear that maintain is not clear. So my suggestion on this would be, first of all, we have the data. We'll be able to go back over 2018 and see how many cases were reopened each month for good cause, essentially, which is reasons other than new evidence. So we'll be able to set something. But I think in order for it to be meaningful, it has to be compared to something. It has to have some context. And what makes sense, I think, is that we look at the number of cases that crew is actually resolving and compare then the number of cases that are being reopened. So, crew gets a number of cases every month. They don't necessarily resolve that same number every month, but of the cases that they resolve, they do usually one of two things. They either decide to keep it closed or they decide to reopen it. Either they're reopening it because of new evidence that we didn't know before, or because they think we got it wrong. And we're focusing on we think we got it wrong. But if we look at that in comparison to the number of cases that they recommend stay closed, then I think the metric, whatever we determine it to be, will be more meaningful because it's supposed to be a quality control measure.
I'm fine with that. All right. So if you guys are okay with that, I'm going to make those modifications to the metrics. Then you'll see it reflected in the next reporting cycle. Given the time, I don't know, Alan, if you're going to want to go through in detail the last portion of this metrics report, which is on the global metrics. So these are not specific to any office. These are recidivism and procedural fairness. This is attachment B to the agenda item. You've seen this data previously, though this has been updated. My suggestion is that we consider devoting a significant amount of time at a future, perhaps the next RAD meeting to discuss it. If you don't want to do that now, because there's a lot to dive into here, I would just say that similarly to the discussions we've been having about defining a goal, we need to do that around recidivism. Some of the numbers here are pretty startling in terms of very high recidivism rates for certain case types. But we need to have some kind of process for determining what reasonable levels are, because obviously 0 is not reasonable. And then once we set that, we need to measure and benchmark ourselves against it. The same could be said for procedural fairness. What's interesting here is you see that our sense of procedural fairness on both the access and the fairness scales are higher for cases that close in investigation than for those that close in intake. And that, I think, intuitively makes sense. They've gotten more attention and they've spent more time has been spent on their case. But this data, we need to dig into it further and we need to set targets for it. Right now, the procedural fairness data you have only reflects responses from complainants. So we have not yet initiated issuing these surveys to respondents, but we will very soon. And we also have not issued surveys to those whose cases make it all the way through to State Bar Court. Right now, we've been focused on cases that are closed in OCTC. So the next phase will extend this to respondents and extend it to cases that are closed in State Bar Court. So here you have our most up-to-date data analysis. We also did provide you with the actual surveys themselves, the questions, so you can see what folks are being asked in the agenda item. So happy to take questions or comments. I do think it deserves a longer discussion.
Yeah, I
perhaps
agree.
at the next meeting.
I think that's when we should do it because obviously there's a lot to talk about, but also we'll have further information at that time. We can do it all at one time. But if there are any questions for Leah now, we'd be happy to entertain them. Okay, seeing none, that concludes the agenda, except that we have one member of the public who would like to make a comment that we had a glitch apparently at the beginning and we had a miscommunication of correct telephone numbers. So we finally caught up and I believe we're about ready to go. Okay, thanks. Okay, is Bridget Graham on the line? Oh, calling her now. Thank you. So this will be Bridget Graham from the University of San Diego Center for Public Interest Law.
This is Bridget.
Hi, Bridget. This is Alan Steinbrecher, chair of the RAD committee, and you are on the speakerphone. I understand you have a public comment, and if so, please go ahead.
Yes, thank you. I'm sorry that I'm not in there in person to be able to make this comment, but I've recently been contacted by an individual who lost her home to foreclosure in the Inglewood area, and she experienced significant personal loss to her attorney due to her attorney's misconduct. And while her attorney has since been disbarred, and she is likely to recover from the client security fund, it's really likely that her attorney was one among many that perpetrated this series of fraud on the individuals and the residents of the city of Inglewood. And the reason I'm bringing this to your attention, I'm hoping that you will put this on a future agenda to talk about a little bit more deeply. I know it's not on your agenda item for today, but it raises two issues for me. And the first one is, I'm wondering, and I really don't know the answer to this, if OCTC investigative staff kind of consider complaints like this on a bigger picture level rather than just on an individual attorney-client complaint level. Because according to this woman's experience, what happened was she complained against her own attorney, but she also filed complaints against other attorneys that were involved in the foreclosure of her home. And I think specifically what raises issues to me is that this is in the area of this development where the new stadium is going in. And I think, and I've been hearing stories about other people in the same boat. And I'm concerned about that for this vulnerable population. I just wonder, even though if you're looking at this investigation from the standpoint of an individual client-attorney relationship and an individual complaint, it might not, rise to the level of discipline. But if the investigative staff are meeting together to identify bigger patterns that are causing problems in particular communities, I think that might be something that should be considered. So that's one issue. The second issue is I think it just kind of raises a transparency and a perception issue that this woman, and I think she's not alone in feeling that an attorney who is investigating his peers sends her a letter and says, "We're closing your complaint. You really don't have a case." She just feels like, well, he's just not taking me seriously because that's one of his friends who represents, big business. And so it just creates this perception to the public that maybe the bar is not considering or taking seriously, important allegations of fraud against bigger companies. And so I think it's something that I've experienced at the medical board too when it comes to relationships with individuals who are filing complaints, that there might be better ways of handling internal intake or being able to help them to translate what the actual problem is, and also to help them to resolve their complaints in a way that they feel like they've actually been heard. So I'm happy to work with you and address this, and I know it's not on your agenda for today, but I just would like to request that you add it to an agenda later on for something that you talk about.
Okay, thank you very much. I appreciate it. And,
thank you. I appreciate the call.
Okay, thank you. Goodbye.
Bye-bye.
All right, the RED committee is now adjourned.
Are we good? John? No? Never mind. Okay. Now we're good?
I think so.
I'm going to call the Finance and Planning Committee meeting to order. We start with the roll call. Here. Do we have any public comment before we begin? Seeing and hearing none, we'll go ahead and move to business item A, the fourth quarter investment and client security fund report, presenting by John Adams.
Good afternoon, everyone. So I just have a quick PowerPoint, and I'm just going to start off. So this is the fourth quarter financial reports as required by the board book. It is prepared by the Office of Finance. For this quarter, it only includes the investment report and the client security fund report. It is as of December 31st. And the reason why it doesn't include the fourth quarter actual budget to actual reports is because we're in audit right now, and that will be presented to the board and to this committee in May with the audited financial statements. So just quickly on the investment report, as the report highlighted, our investments are $109 million, and this is in comparison to $106 million in 2017. Average rate of return was 2.43%. Earnings almost significant increase based on interest rates at $2.9 million for the fiscal year of 2018. Our LAIF rate, which is the state's rate, increased significantly over the year based on increase at the Fed level. Highly rated securities, highly restricted by the government code, and our investments are in compliance with the board's investment policy. So moving on to the client security fund, part of the report includes 5 attachments. These are those 5 attachments. I won't go into each one of them. I do want to provide you just the simple highlights. New applications actually had a 6% increase from over 2017 with more money being requested. Total applications, though, did decline, but dollar amounts did increase. Total payouts increased significantly over the year. That was because of the board's action to change the reserve policy for CSF, so it made more money available for payouts. Plus, there was a $250,000 transfer from LAP into Client Security Fund. And I'm just going to note the bottom, which is the reserves available in CSF is $0.4 million, so certainly just enough to pay for administrative costs. And again, that helped in the pay down for 2018. And with that, the recommendation in front of the committee is to approve the reports. So I'm available if there's any questions.
Do I have any questions or motion?
Move the recommendation.
Alan's moved. Do I have a second? We have a couple of those. Do you have any objection to substituting the roll call? It's approved. Now we'll move on to item B, review of the cost allocation policy.
All right, since I love PowerPoints, I have a second PowerPoint for you. This item is to approve the cost allocation policy. Wanted to just go through quickly what I'm going to cover, talk a little about the background, a little history on the policy, or the plan, I should say. really the purpose and goals for the cost allocation policy. Just briefly explain direct and indirect cost, discuss our allocation basis, indirect cost centers, programs charged, and then want to just briefly touch on technology projects and then provide the policy for your adoption. So just quickly, it's highlighted in the board report. Original plan was developed in 1999 by then Deloitte & Touche. It was updated in 2001 for the budget in 2002. It's been mostly unchanged. Minor adjustments as time has gone on. The Bill Statler report in 2016 identified minor changes had been made, but in substance is pretty consistent over the years. It was part of the state auditor's review in 2015. They actually had some recommendations or some findings related to how we allocate technology. And then in 2016, the Statler report more or less summarized that the plan was technically sound and was reasonable. And it did have two recommendations, and that was to adopt a cost allocation policy and adopt a cost recovery policy. The cost recovery policy hopefully will be back to the committee by the end of the year. Today, we're following up on the recommendation to adopt a cost allocation policy. So this is sort of the recommendation. This is why we're here, and I just decided to cut this from the Bill Statler report, which is an attachment of the report, and just more or less says that the board should adopt a policy instead of this cost allocation plan, which is convoluted and it's a large worksheet that has embedded formulas is the summary of the recommendation. So the purpose is to allocate costs to the various programs so that they pay for their fair share. The policy goals, as you see here, is to make sure that restricted revenue programs pay their fair share, and that we showed not just direct but indirect costs for those programs. Just a brief definition of direct and indirect costs. Those that we identify as direct costs will be charged directly. Those in indirect cost centers like HR and finance are allocated. Here are your basis in which we allocate, or what we consider our cost pool. You can see everything from the executive director's office, the board of trustees, to HR, to information technology, finance, everything that we would consider overhead. This is our cost centers and the values that they had in 2019. The largest cost center is information technology. General services, when you combine them, is the second largest, or maybe it's the first largest. Here are the programs that they're charged. What's interesting is over 75% of what is charged through indirect is actually charged to the general fund. So you can see the other programs that actually get indirect costs allocated to them. Admissions being the second largest program that the bar has related to personnel is the second largest, and they get 15%. So just briefly on technology projects, I want to be clear that as technology projects come, those allocations are done on a case-by-case basis. A good example is the admissions system. The new AIM system is being allocated directly to admissions, and so there's no reason to allocate the cost for that technology project to other programs, whether that's in general fund, client security, or LAP. That would be an example where we do the evaluation, it benefits admissions, and thus the admissions program pays for the full amount. So with that, I'm certainly available for questions, but in front of you is just the recommendation to adopt the cost allocation policy. So.
Moved by Jason. Do I have a second? Second by Renee. Do we have any further discussion? Any objection to substituting the roll call? Okay, thank you, John.
Thank you.
The last item on our agenda has to do with reviewing the strategic plan, including metrics, the planning portion of the Finance and Planning Committee. Do you want to take it, Leah?
I'm going to walk over there. Do you want to say sort of what you're hoping?
Okay. You may recall that we received a Smart Sheet link that kind of listed all the objectives and what portions of the objectives are being met and the deadlines and so forth that are set out under our strategic plan and goals. Leah and I talked about it, and John and Hylin during one of our phone calls about what role we need to be taking as a committee with respect to oversight of these, of the progress that we're making. And we were discussing about maybe each time we meet, finding a couple of items that we should be discussing just to make sure that everything on that smart sheet is being addressed and looked at by the board, especially in particular those items that are delayed or not moving forward. So with the staff's help identifying those most important items for us to discuss, we were thinking that's how we might proceed with this particular aspect of the committee work. Leah?
Okay, so just again, a reminder that you do have access to this smart sheet, which I am keeping updated, and it is structured by strategic plan goals, and you have here the objectives that are on the published strategic plan as well as the implementation steps. The overall status is displayed here. Then if you move over, you can see the expected start and end dates, which chief or myself the item is assigned to, and then any comments. So that's the way this structure works for the smart sheet in general. The only other thing I would add is that for some of these where you see a little paper clip, that means there's an attachment, and it's sort of in that attachment we're describing the exact implementation steps that are intended with respect to that particular aspect of the smart sheet. So that's the overall structure. For this particular meeting, I thought that we could talk about goal 2, which is our discipline and admissions, and talk specifically about goals that we have around self-assessment. So I'm looking for those specifically here. Here we go. So we have this objective, which is no later than July 1st, 2021, create a fully articulated preventative education approach to include a self-assessment component, as well as client trust accounting modules, which may be mandatory for some attorneys. We are not in compliance with this now because it's not until 2021. But as you know from reading your agenda for tomorrow, we have a report from the Malpractice Insurance Working Group, which contains a number of recommendations, including those related to self-assessment and preventative models for handling circumstances where attorneys do not choose not to have malpractice insurance. And so I highlight this here because we do have related objectives in our strategic plan. The board and finance and planning may in fact recommend that we modify the strategic plan in light of the recommendations that are contained in the Malpractice Insurance Working Group report, that we may in fact want to accelerate this component of the strategic plan. So that's one that I thought that we could highlight. In addition, there is a requirement here that we are delayed on. No later than January 1, 2019, require all attorneys to report firm size and practice type. Now, we have launched a new, very robust survey. We are collecting this data, but it is not a requirement. And when the strategic plan was adopted, there was the intention that this would be a requirement. If you'll recall, the reason for that was the idea that we would initiate preventative education, particularly perhaps mandatory preventative education, when attorneys transitioned into a solo practitioner status. So right now we're collecting the information, but it is voluntary, not mandatory. So in order to make that mandatory, we would need to promulgate state bar rules. And that's a question as to whether or not we want to do that. Certainly our strategic plan suggests that we would. So that's one where we aren't in compliance, and we have to decide what we are going to do. So I'll just pause there.
So a question I have is, For this committee, would the idea be, we see these items that need some attention, and do we discuss it as a committee and then perhaps ask that the appropriate committee that it falls under take action on those items? Is that what you're seeing?
I think that would be appropriate as we try to build some structure around how do you all use these tools to hold staff accountable. I think that makes the most sense. Now, there are some areas, and I could go to goal 3, which is where we're really looking a lot more internally, looking at things like performance accountability, training and professional development of staff, staff morale, career satisfaction. These parts of our strategic plan, and similarly the related metrics that we have for the bar in those areas, say HR, for example, or even finance, they don't have necessarily a committee home. And so I do think for those that don't have a subject matter committee home, it would make sense for finance and planning to be that home. So perhaps for those aspects of the strategic plan clearly aligned with programs or RAD or the executive committee, then the Finance and Planning Committee's role would simply be to flag areas that you'd like the subject matter committees to follow up on. For those areas of the strategic plan that do not have another home, these are great examples here, those having to do with employee engagement. Finance and planning could serve in that capacity. That would be one way that we could structure this going forward.
Okay. Do I have any discussion among the committee members? Any thoughts on how we're doing this? Any better ideas? Jason, you have a little steam coming out of your ears. Are you thinking?
I hope there's no steam generated by this discussion.
There's no steam.
Okay. Okay, so with respect, for example, the last item that you were talking about, totally blanking on which one it was.
This is reporting on firm size.
Yes. What committee would that fall under? Would it fall under any?
Well, that's a good question. It could fall under programs, which is where attorney regulation and consumer resources falls. Or it could fall under RAD because it is it's preventative education. The idea is that you're going to prevent, I'm looking for it now, you're going to prevent future discipline. So I think I would lean perhaps towards RAD, but I don't have strong feelings about that.
Funny, because I was leaning towards programs. Do I have any thoughts from the other committee members? You're leaning towards programs, Alan?
Chair of RAD, co-chair of RAD. It's a self-interested, a conflict perhaps.
Okay. Do I have a less conflicted view? Yeah, Jason.
Just in terms of the chairs of each respective committee tracking the applicable objectives, would it be worthwhile to sort of propose where each of these objectives fall within the committee? And then we could use our handy labeling and, like the programs chair could just sort and then see everything that is associated with the programs committee.
Yes. But you still haven't opined as to where you think this particular one falls.
Oh, I didn't feel like I needed to. It seemed like it was working itself out.
Okay. All right. So I think that's a good suggestion. We can sort of akin to what I did for the metrics, where there's the RAD metrics and the programs committee metrics. I can pull out also the finance and planning metrics, which I would recommend would be HR, general services, those that don't have another home. And I can do the same thing for the strategic plan, kind of resort this. And what I will do for each meeting then is do sort of an overall report card flagging those where we are delayed or we're not sort of meeting the expected performance target or timeline target, with the idea that we would discuss at Finance and Planning more substantively those that don't have another home. For those that do, could be a referral out and ask for future follow-up.
So with respect to this
Yeah.
requires a rule change. So it needs to be on somebody's work plan. And I'm not sure it is right now, is it? It seems to me this committee should refer it to a work plan to be done by a certain date. Obviously, it can't be done by the date that just passed, but we should ask whatever appropriate committee
Yes.
to include it.
Let me see. Donna, I see you're in the smart sheet now. So do you have any thoughts on programs versus RAD for this one? No, firm type and firm size. Right now, Leah, Donna, and Melanie, we're all very delayed, but it's Melanie that suggests RAD. So perhaps
Really? I haven't heard her say that, Leah. I'm only hearing you
Leah,
say
Donna,
that.
and Melanie were to draft a project plan by May 1 of 2018. We did not do that.
What if it landed with audit? It's an accounting issue.
Okay, I think we're spending too much time on this. Okay. Perhaps, Joanna, as the chair of finance and planning, you can make a decision, let me know what your decision is, and we'll handle it that way and get it assigned out.
Okay, let me be as diplomatic as possible. Okay. I'm going to leave it to staff to decide amongst themselves, but it's going to be a cage fight. You need to invite us to determine what committee that should be assigned to. And to make sure it gets on the work plan for that committee to discuss and adopt for their next meeting, preferably. So we can make sure it has a deadline and it's on somebody's radar.
Okay.
Assuming it's not already there. With respect to the other item, the first one you flagged, we're going to be talking about that further tomorrow.
Mm-hmm.
Maybe part of our discussion could also be, what committee that should take that on and getting that on a work plan as well.
Okay.
Any other thoughts? Ellen, RAD is still a possibility, sorry. Oh, darn, your mic's not working. So.
My thought is that since neither the chair nor vice chair of programs is in the room, it's good.
No, I'm going to let staff take that one on. Okay, if there's no other discussion, we are adjourned.
There we go. Audit Committee, come to order. Can we take the roll, please?
Mark Broughton,
Here.
Sonia Dellin. Here. Ruben Duran,
Here.
Renee LeBron. Jason Lee. Here. Debbie Manning. Joshua Pertula. Everyone's here.
Okay, there's very little on our agenda today. Unfortunately, we're already over time, so I can't catch up to make it good. But in any event, is there any public comment from anyone in the room? On the phone? Hearing none, there won't be any chair's report today. There'll be probably a lot more on our agenda in May. But for now, we'll just move, actually, I'm sorry?
You can just see if anyone wants to move it.
Where are we?
You're just accepting this report.
Right. Do we have consent agenda? I can't see the thing there.
Oh, sorry, there's only one agenda item.
Without a computer, I don't have an agenda.
There's stuff, yeah, it's on consent.
Okay, we have one item on item A on the consent agenda. Any objection to substituting the roll call? Okay, deemed accepted. And now the only item on our business, I'll turn it over to John Adams.
That was consent, you're done.
I'm sorry?
That was consent.
Oh, he's consent.
Yep, you're done.
We're done. Okay. We're adjourned.
Hello?
This is why I upgraded the restaurant. I just wanted to say I knew who wasn't coming, so.
Oh, that sucks because you knew I wasn't.
I don't think we'll have like 4 people there. Yeah, he has a client thing. Client. I know. All right, do we have everyone here? Oh, wait for Leah. Okay. Can we shoot to be actually out of here? Okay. Hello, everyone. Convening the XCOM committee, Jason Lee, chair. Can I please have a roll call?
Jason Lee,
Here.
Alan Steinbrecher,
Here.
Mark Broughton,
Here.
Ruben Duran,
Here.
Renee LeBron, Renee LeBron.
She left.
She's gone.
Okay. Debbie Manning. Here. Joanna Mendoza.
Here.
Brandon Stallings. And Leah Wilson.
This is a call for public comment. If there's anyone out there who wishes to make public comment, this is the opportunity to do so. Seeing no one, I'll move on to a very short chair report. Now is the, I guess, season to put in your application for many opportunities at the State Bar, many rewarding opportunities at the State Bar. So a question has been posed as to who do you contact when you want to know everything about those opportunities and the agency, and those people are Brandon Stallings and Mark Broughton. So your inbox is now flooding. I'm looking at you, Mark. It's a convenient time for Brandon to be gone. As there's nothing on the consent agenda, let's move to the business items. Let's go to 3A, which is approval of the 2019 legislative priorities. And that's, what did you say? McLeod, where are you? Dag. Go ahead, Mr. McLeod.
This is the second year that I've been responsible for pulling together information on the proactive legislative agenda of the State Bar. I'm very happy to have Kim Da Silva here to present this item and go through the issues that we've identified to prioritize in the 2019 legislative session.
Yeah, I think what's going on is whoever's on the phone, if you can hit mute, we can hear some talk. Thank you.
Thank you. Thanks, Suzanne. Okay, I can make this brief. So this agenda item sets forth the State Bar's legislative priorities for 2019, requesting approval for the individual proposals described. The number one priority for the legislative program this season is to secure an increase in the annual licensing fees paid by attorneys. The income for those fees, as you all know, has remained stagnant for over 20 years, and it forms the largest portion of the bar's operating budget. The State Bar needs to increase those fees because it's currently working under a structural deficit that's not sustainable for the organization and its important work of protecting the public. The remaining proposals, and again, I'll be summary, break down into substantive and technical cleanup proposals. The substantive proposals include 6001.2. This proposal would repeal 6001.2, which created the governance in the Public Interest Task Force, because the work it was mandated to do has been accomplished with the final Appendix I resolutions last fall. There is also, should that statute not be repealed, there's also a technical amendment or a cleanup amendment that would get rid of references, outdated references to elected members. Members aren't elected anymore. The next proposal is 6074. This proposal would amend Business and Professions Code Section 6074 to clarify the State Bar's responsibilities with regard to coordination of pro bono civil legal assistance to veterans. Right now, the statute has the State Bar coordinating certain efforts, but it's just not as clear as it should be for the bar to know what it needs to do and to comply with that. So trying to tighten up that language. There's also a technical amendment that would clean up, it would delete a reference or requirement that the bar pursue or do a survey, because the survey has been done already. That work's been completed. The next proposal, Business and Professions Code 6076.5. This proposal would repeal that section because it prescribes a process by which licensees of the state bar can formulate rules of professional conduct through an initiative process based on outdated state bar voting districts. So it's just based on an outdated organization of members. There's also a technical amendment should that statute not be repealed. There's also a technical amendment that would, again, delete the outdated language in that statute. The next proposal, 6093.5, would amend that statute to require, which requires the state bar to follow up within a certain time frame on inquiries about inquiries by complainants as to the status of their complaints. The amendment would clarify that the state bar is not required to continue acknowledging new complaints from complainants. We'll just keep going. Who submit an excessively large number of complaints that are deemed to lack merit.
Kim, if I may interrupt you.
Sure, please.
Please do. We've taken the vexatious complainant off the, took it off the agenda. Yeah. So I think this comes off, this should be amended to come out for now.
Oh, for now, okay.
Until we resolve that.
Okay, so that one, so the resolution or the proposal would be without that. That's proposal. The rest are, again, as I said, cleanup proposals. I've already mentioned 6001.2 about governance in the public interest task force. If that statute's not repealed, it would just amend it to clean out outdated references to elected members. 60 Business and Professions Code 6022 would repeal the whole section because it's regarding selection of a secretary annually by the board. This is more of a management function that falls under the general management of the executive director. These are all Business and Professions Code sections. So 6074. So in addition to substantive changes regarding the pro bono legal assistance to veterans and their families, this proposal would amend the statute to eliminate, as I said earlier, eliminate the reference to the survey that was already completed last year. Just a few more now. 6076.5. This is the technical amendment to the substantive proposal regarding initiatives by state bar licensees for rules of professional conduct. If the statute is not repealed altogether, this proposal would eliminate, again, outdated references to state bar districts. The next proposal would deal with two statutes, 6025 and 6026, and it would amend 6025 and repeal 6026 because they're based on a discontinued practice of holding one annual meeting per year. Clearly, the board doesn't do that anymore, so they don't really make sense. The next proposal, 60 regarding Business and Professions Code 6052 and 6077. These contain language regarding the issuance of subpoenas and the imposition of sanctions, and those two statutes have the board doing those two things. The board doesn't do those two things anymore. The state bar court does those, so it would just be to update the language with regard to who performs those duties. And lastly, 6013.1, 6013.3, 6013.5, and 6016 would all be amended to clarify that those statutes all deal with appointments, and they would be clarified. They would clarify the beginning and end of the board year. It's not clear in those statutes what the board year is, and that is it. So, with that, deleting the proposal for Business and Professions Code 6093.5 would propose that the committee approve the recommendations.
I had a question with respect to the governance task force.
Sure.
Technical amendment. I'm hoping we obviously can get rid of it at this point, but in the event that we can't, an issue that Michael Colantino raised multiple times during the years had to do with the makeup of the governance task force because it didn't include either of the attorney members from the legislature. It was just public members. The way it was worded was not. It didn't encompass everybody on the board. And I think that if we have to keep it, we need to look at not just that, but just the makeup of the governance task force, considering the really shrinking size of the board, and whether or not we need all the members that are currently identified there, and if we need to broaden the scope. It just needs to be looked at generally, not just with respect to getting rid of the electors.
Okay.
So let's hope we don't have to go down that road, but if we do, I really think it needs to be looked at in a broader technical sense.
Okay.
To address the cases out as we hope just be eliminated, but the amendment does not. How do we supply information to the legislature so that they are constitutional accessible?
I think we could handle it sequentially through the ledge liaison process that we have set up, so we can get feedback as to where this particular proposal is going. If it looks like it is not going to be able to advance, we can work with the ledge liaisons to address this concern.
Okay.
And then through Jennifer.
So, yeah, and so that would really be the only kind of change I'd make to this, just to make that technical change broader and
Okay.
Any other questions? Thank you.
Thank you.
Oh, sorry. We do need to do something. So there's a proposal up on the screen. Debbie, second. Roll call. Any objection?
Thank you.
Done. Moving on to the next item, and the next and final item on the agenda, which is board book. Kim is presenting. I just want to say, Kim, before you start,
Sure.
A real special recognition to Joanna and Sean, who have last night grew up there. Good. We spent a lot of time to streamline so thank you.
Yeah, I second and third that. The trustees Mendoza and Select have been amazing with their oversight of this project, so I'm also very appreciative. So this agenda item presents the revised board book for approval by the board executive committee. I'll be brief, but this item really does represent the culmination of a comprehensive revision of the board book in years of work. So the State Bar's Board of Trustees Policy Manual, commonly referred to as the board book, is what we're talking about. It's the attachment to this item. The existing board book was adopted in September 2004 as a compilation of statutes and State Bar rules and board resolutions. And over time, with the addition of resolution after resolution, it became extremely unwieldy. The revision process started at the request of the board in 2015 with just discrete portions. And last year, the bar contracted with a retired public sector executive with experience writing board manuals to really help turn it into a more accessible tool. And staff's updated the committee on that process since then. Just briefly, certain material was removed entirely types of those types of material were recitations of statutes. There were a lot of just statutes in the board book that really didn't need to be put verbatim into the manual. Extremely detailed information was also taken out, and redundant material was removed. Certain materials also, this board book is intended to be a tool used by the board as opposed to staff. And so staff procedures were removed and will make their way into staff manuals. And historical annotations were also removed. The board book does retain the following categories of materials. It still retains governing authorities, board composition, meeting procedures, sub-entity rules, fiscal oversight, legislation and rulemaking, staffing, communication, expense reimbursement, board member training, and ethics and conflict of interest. Okay, I'll just summarize again. I know it's a little tedious, but it is a lot of work, and it's turned into a really good reference manual, I think. Since the last board meeting, there's been a lot of vetting done to the revision. Office of General Counsel has helped out with technical assistance on a number of questions. They've written certain sections, and finance also helped out with the section, and then Trustees Mendoza and Seleg really have put in exhaustive reviews of both the text and the appendices themselves. If the committee approves the revised board book, it will supersede and replace the existing board book with two exceptions. Two of the appendices, Appendix G with sub-entity charters and Appendix J, a conflict of interest authority, are not included in this revision at this time. Appendix G will contain sub-entity charters, and there's still work going on, triggered by the board's decision, Appendix I decisions last fall. So once that's complete, and the sub-entity charters can be developed, then that will be brought forth to the committee and then the board for inclusion into in the board book. Also, Appendix J, which contains just the authority underlying the State Bar's conflict of interest policy, wasn't quite ready to be included, and so again, that will be brought to the committee and then the board for inclusion. Until those two appendices are brought forward for approval and ratification, in terms of Appendix G, the Section 5 of the old board book, to the extent that it contains material on existing sub-entity charters, that will remain in place. Appendix J, with regard to the authority underlying the conflict of interest policy, until that's brought forward and adopted and ratified. Tab 3.1, Article 4, Conflict of Interest Code for the Board of Trustees of the State Bar of California, in the existing board book will remain in effect. New policies, very quickly. You want to talk?
No, I just have my favorites, so you go ahead.
Oh, okay. So the last thing is just there are a few new policies in the revision. The revision is less than 30 pages long, I think, which is pretty amazing. So new to the revision, in the appendices, all of the standing committee charters are still there. Those standing committee charters were last revised. Trustees wanted this to be said in January of 2018. There's only one change to those charters, and it's in finance and planning. Finance and planning would, if this is approved and ratified, one item would be added to their duties, which would be
essentially the planning part of finance and planning, or oversight of
the metrics.
Yeah, the metrics.
So overall monitoring of the State Bar metrics is being added. That's underlined in the charter. Global rule changes for sub-entities, just all the decisions the global decisions of the board from last fall are now written down somewhere, and that somewhere is the board book.
new articulation of the conflict of interest policy. So my understanding, it's not a new policy, but it's been rewritten and clarified and is in here now. Just looking at Vanessa. Okay. And there is also a new email policy. We do have someone from OGC who's available for questions should anyone have any. But there hasn't been an email policy, to my understanding, until now. And so that's new to the board book. That email policy encourages board members to use their State Bar email addresses when conducting State Bar business. And lastly, the revision makes it explicit that the performance evaluations of key staff, the executive director, chief trial counsel, and general counsel are to include 360-degree reviews. Joanne?
I wanted to first let you all know, Sean and I have read every single word of everything. It's so you didn't have to, and any of you can buy me a drink tonight, and I will be gladly accepting that. But it should give you some assurance that there's been two sets of eyes that looked at all of this, and we've been really working hard to get there. And I don't want to question the 2015 date, but I swear I've been working on this board book revision since I got on the board in 2013. So it has been a long process. I'm very excited that we're here. My favorite policies, and I know you're all wondering what those are. We have we very clearly clarified the issue of being able to speak on behalf of the state bar with the legislature, anybody outside, and the amicus policy. Those have been problems for us, as we all know, for a while, especially with respect to the sub-entities. And those have been made very clear, who can speak on behalf of the state bar, what they can say, how they can do it. So those are my favorite parts. So if you're going to only read anything, I would recommend you read those just because they are so darn exciting. But other than that, I hope that because it's about 270-something pages shorter, you might actually want to read some of it one of these days, because it even has a table of contents, which we didn't have before, as far as directing you to a page to find something as simple as that. It makes it much more user-friendly, not just for the board, but for our sub-entities who might be questioning what we're doing. I think we've laid out pretty well what the rules are and the oversight role of the board is.
That reminds me, it also has a nice numbering system
That's
that
true.
Sean Selig suggested, and it really works.
No more tabs.
It's really easy to find things. It's 1, 2, 3, 4, just to 10, I think 10, 11. And it's very
Can't you tell? It's just the room is oozing excitement.
It's exciting.
Yes.
It is exciting. I can tell.
I think Vanessa has 2 issues she wanted to raise. Go ahead, Vanessa.
Right. So the first has to do with the 8.3, the electronic communications policy. And it currently reads that board members are encouraged to use their State Bar email address, or in the alternative, to copy or forward their State Bar email accounts when conducting State Bar business. In the event that the board wants to make use of the email, of their new email address as mandatory, now would be the time to chew on that issue. We give these alternatives here. The other thing is, I would suggest that the resolution that says replaces the old board book with the exception of Appendix G and J, we add to that Section 7.4, State Bar Court. That needs to be refined. It's not exactly accurate as it stands right now. And I would just say somehow weave it into the resolution that OGC will rewrite that section to conform to the law and rules pertaining to State Bar Court judges.
I'm sorry, could you give me the number again? Could you give me the number again?
Of the section that we would review, 7.4, State Bar Court. Because you're bringing it back for G and J, so we could do that at that time.
No problem.
Vanessa, on your point about the email use, and you said for us to chew on, is this this is not something we're going to do now, but rather you're flagging for us that it.
No, you would do it now because you're voting on the board book subject to these 3 changes. I know Sean's not here, but I know, I think he didn't want, I don't know if Suzanne's on, but I think he didn't want it to be required. So encouraged is a kind of loose term. And the reason for this, by the way, is not only for your own segregation and privacy, but if we get a discovery request, it's really nice to have it all in one place and not have to invade the board members' personal or professional accounts. And it preserves the confidentiality of the state bar court, the state board communications from your professional accounts, which others have access to. So OGC loves the idea that you would all get a state bar email address and use it exclusively. But if that is a difficulty in relation to your work or something, it would read board members are to use or in the alternative to copy or forward, et cetera, et cetera. But we kind of put it this way so that the executive committee and the board could discuss what they want to do.
Yeah, I can speak on behalf of that, but Sean and I both agreed that it wouldn't be appropriate at this time to put it was required, that the board would need to fully discuss that and come to that conclusion. So, yeah, we were both in agreement with the language that's being proposed, that it's being encouraged. And if we want to do something more draconian, we certainly can.
Are you signaling something, Joanna?
What? What did I say?
Any other comments on that issue? Right, so one way we could do it is I do believe it should get the full board attention if we were going to require everyone on the board to utilize state bar email, that we would pull this portion out, the consent, and have that discussion at the meeting. But I think that's really the way we would do it. Because I don't think we should make a decision on what the board should do.
Well, as it's currently drafted, it just encourages the use. And my suggestion is we go ahead and proceed with adopting the board book as it is. And if we want to set that up for a later date to change that provision, we can. But I don't want us to get caught up on one policy in here that we can raise later to change, since right now it's not requiring it.
Yeah, and I'm agreeing with you. I support passing on the board book to the full board meeting, and I was just saying if we really wanted to deal with the email this session, then someone would have to pull it off consent to address that email issue. But I think as it is,
okay,
it's fine unless someone else disagrees.
Actually, I think it's on the discussion for the full board meeting.
I think this should be attended. Go ahead. Okay. All right. Can I have anything else? Have a motion? Mark, Debbie with the second. Can I substitute roll call? Being approved. Thank you.
Thank you. Thank you, John.
With no more matters before the executive committee, I will adjourn the meeting. Thank you.